Mr. Stickley. Good morning, everyone. Mr. Beerline, I think you're supposed to be in the courtroom next door. Yeah, we charge admission on this side. It's free over on that side, so you can go over there for free. All right, everybody, good morning. Let's get started. Good morning, Mr. Stickley.
Right, Judge.
You look like you got what I had.
I'm on like 2 weeks. I get better and then
Yeah, that's the way it's been. All right, well, let's get started. Clowns to the left of me, jokers to the right. Here I am. Guess he was pretty prophetic about 45 years ago. Don't know why I came here tonight. Feeling that something ain't right. All right, we're ready to go. Michelle's here, Keith's here, Mr. George is here, Vivian's here. I appreciate everybody who helps us make this happen every morning. I'm in here doing this by myself, but I'm really not. It takes lots of people to make this simple arraignment process work, not to mention all of my staff. Vivian, I'm ready if you are.
I'm ready. I have my camera turned off because I think where I'm at, the reception is not that great.
All right, well, thank you for joining us. Well, first thing I'm going to do, wherever you are, would you please raise your right hand?
Yes.
Not you guys, I'm sorry, but thanks anyway. I wasn't very clear on my instructions. I'm going to swear in the interpreter. And Luke, you swear or affirm to the best of your ability you will interpret these matters from Spanish and English into Spanish.
I do.
Thank you. Luke, are you here for Mr. Harvey?
No, Judge, it was Mr. Philip Yoder, Village of Constantine.
All right, well, I may need your help on Mr. Harvey.
Okay.
But we'll see. All right, Senor Oswaldo Ramirez Gonzalez, would you come forward, please?
Puede pasar adelante, señor Ramírez González.
I did. Don't bring it in.
Okay, that's what I wanted to see. I didn't want to have them sit around for.
No, don't bring it any.
Okay, thank you.
Thanks. Buenos dias.
Buenos días.
Es usted Oswaldo Ramirez Gonzalez?
Sí.
Yes.
The lady that's helping us, you can't see her, but she is a certified court interpreter, and she's going to translate and interpret for us.
La señora que está en la línea, no la puede ver, ella nos va a ayudar. Ella es una intérprete jurídica certificada.
You got a ticket in Three Rivers on November 25th.
Te recibió una multa en Tres Ríos el 25 de noviembre
For driving without a valid operator's license.
por conducir y no tener una licencia de conducir vigente.
We get lots of those tickets, hundreds.
Recibimos cientos de ese tipo de multas.
Okay. It is a misdemeanor.
Es un delito menor.
It is punishable by up to 90 days in jail and a fine of up to $100.
Conlleva la máxima penalidad posible hasta 90 días de cárcel, la multa hasta $100.
Plus cost.
más costos.
Let's take a look at your ticket.
Vamos a echar un vistazo a la multa que le di.
You got the ticket at Broadway and Constantine Street
Usted recibió la multa entre las calles de la Broadway con la Constantine
at 8 o'clock in the morning
a las 8 de la mañana,
on November 25th.
el 25 de noviembre.
You got a ticket in October
Recibió una multa en octubre
and it says you don't have a valid license, but you have 2 points on your license.
Dice que no tiene una licencia vigente, pero tenía 2 puntos en su historial de conducir.
I haven't received a bond.
Well, we had a couple walk in, so we're always open. Anyway, sir, the normal fine for that is $100 plus $125 of costs, $225.
Normalmente la multa son $100 más los costos de 125, un total de $225.
How do you plead to that charge?
¿Cómo contesta usted a ese cargo?
Culpable.
Guilty.
Culpable.
Guilty.
Did anybody threaten you to get you to plead to that charge?
¿Alguien le amenazó para que contestara culpable?
¿Puede repetir?
The interpreter will repeat. ¿Alguien le amenazó para que contestara culpable?
No.
No.
Or promise you anything?
¿O le prometieron algo si contestara
No.
culpable? No.
No.
Where were you going?
¿A dónde iba?
Venía del trabajo.
I was coming from work.
Where do you work?
¿En dónde trabaja
y-
usted?
Limpiando bones de maíz.
Cleaning something of corn.
Okay, down in Constantine?
Ya.
In Constantine. Yeah.
All right, well, you can't drive because you don't have a license.
Usted no puede conducir porque no tiene licencia
And I can't fix it.
y no puedo arreglarlo.
How'd you get here today?
¿Cómo llegó aquí el día de hoy?
Me trajo un amigo.
A friend of mine brought me.
All right, do you have a way to get back forth to work?
¿Tiene forma de ir y venir al trabajo? ¿Alguien más le puede llevar?
Sí.
Yes.
All right, the fine is $100.
Multa 100.
There's a $75 crime victims' rights fee
$75 para víctimas de delito.
and a $50 fee that goes to the state.
Y $50 que va al estado.
The state requires that I put that $125 of costs on every case.
El estado requiere que agregue $125 de costos en cada caso escuchado.
So the total is $225.
El total son $225.
Can you pay that today or do you need time to pay it?
¿Puede pagarlo hoy o necesita tiempo para pagarlo?
Puedo pagar hoy.
I can pay it today.
Very good. I don't have
Muy
a
bien.
way to fix this because you can't get a valid license unless you have lawful residency status.
No tengo forma de arreglarlo porque usted no puede obtener una licencia de acá sin regularizar su situación migratoria acá.
There are some states where you can do that.
En algunos estados eso se puede hacer,
But Michigan isn't one of them.
pero Michigan no es uno de ellos.
I just read that the federal government is threatening to take funding away
Acabo de leer que el gobierno federal está amenazando con quitar los fondos
from the states that do give a license to people that don't have a lawful residency status.
a aquellos estados que sí le se da una licencia de conducir a las personas que no tienen regularizada su situación migratoria.
All right, good luck, sir. I'll have the bailiff take you out. You can pay the fine and you can just have to find a way back and forth to work.
Buena suerte, señor, que el alguacil le va a acompañar.
She will take you out to the counter.
Acompáñale al oficial, le va a llevar a pagar y que su amigo le lleva y le trae del trabajo.
Okay, thank you.
Anything else for the interpreter, Your Honor?
No, I think Judge Pattison might need your help next door.
Yes,
but
yes, that's where I'm
it
headed
for-
next.
All right, thank you very much, Vivian. I always appreciate your help.
You're welcome. Have a good day.
All right, we always start with the interpreter's cases because she's usually needed in more than one place at a time. And as it turns out, she's needed next door. It does take longer to do those, but often they resolve easily. Mr. Knopfinger is here on Philip Yoder. Let's talk to him. Mr. Yoder, would come forward, please? Good morning. Are you Philip
Yes, good morning.
Aubrey Yoder from
Yes.
Middlebury? This is 25774OT. This case has got a little history to it. I have to get used to doing it without an interpreter because I can talk faster. You got a ticket back in April and the officer didn't give you a notice. So we sent you a notice in May. We sent a notice on April 30th for you to appear on May 13th. He didn't come on May 13th.
For names, I can tell. Status,
I case consult with case managers. I have not met him in person.
okay. Have you reviewed his file?
Yes,
And are you familiar with the petition that was filed?
yes.
And can you outline the reasons that petition was filed?
It was filed due to concerns related to insight into mental status, also need for medications and ongoing treatment.
Okay. And what type of order is being requested?
An ongoing treatment order,
Okay, so he's already subject to an order right now?
correct.
Okay. Is there anything you'd like to inform the court of? Anything else?
No,
I don't have anything else for her, Your Honor.
Ms. Hansel, do you have any questions for this witness?
Okay, is it your belief then, ma'am, that without this order being in place, that Mr. Steets or Status, I'm sorry, I don't know how to pronounce that, would be in danger for his health or the health of others?
unintentional, yes.
Okay. And if you know it, oh, you said you, okay, I had no other questions. Thank you.
All right. Ms. Brucker, any other witnesses or evidence that you wish to use?
No, Your Honor.
Ms. Hansel, any other witnesses or evidence or any statements that you wish to make at this time?
No, as is, well, I would say, Your Honor, as a guardian ad litem, I would be in support of this order being signed. Thank you.
All right. Dylan, is there anything that you want to say at this time?
No, I'm okay with the order. Keep going, keep on going. And it's Stats, by the way.
Stats, thank you very much for letting us know. I appreciate that. Sorry for mispronouncing your name through all of
It's
that.
okay. It's
And
happened the
you
whole
think
life.
that's all right. Thanks. You think that this order is helpful to you to make sure that you can maintain your good sense of mental health?
Yes, sir.
All right, I do appreciate that. Thank you very much. I will then find that it is appropriate for a second order for mental health treatment to be in place. I have reviewed the testimony of Dr. Gehrman that we preserved from the last hearing indicating the mental health diagnosis, schizoaffective disorder, traumatic brain injury, PTSD, and that he believed that Dylan qualified as a person requiring treatment under the mental health code and recommended up to 90 days of hospitalization if needed. I have heard the testimony of Jennifer Limbesis as the petitioner, indicating that she believed after review of the file that that was appropriate as well. And Dylan has agreed to that. So for all of those reasons, I do find that Dylan is a person requiring treatment and that his judgment is so impaired by the mental illness and a lack of understanding for treatment that he's not able to presents a substantial risk of harm, physical and mental health if he were to not be in treatment. And therefore, I will order the second mental health treatment order requiring treatment and hospitalization up to 90 days, and ongoing treatment.
Going to be incarcerated. We have spoken to the victim of this case, Mr. Krasik, and he has no position with regard to ultimately he feels like the court and relying upon the court and the state to have his best interest at heart as far as what happens here. There is restitution for medical bills that are he is requesting. I believe that number is $11,277.75.
77 or 27?
77.75. Sorry, 277.75.
Anything from probation?
Nothing further than what was discussed in chambers.
Mr. Aldridge?
Several things, Your Honor. First off, the defendant's mother is present. She'd like to address the court.
Okay, come on up.
Ma'am, if you just want to stand on the other side of this table here, in front of this chair. You don't have to speak into the microphone. It's recording you. That chair out of the way. If you just state your name for the court reporter.
Jennifer Buchanan.
What would you like me to know?
I'm sorry. I know my son, I make no excuses for, I don't condone any of his behavior throughout juvenile court and now in your court today. However, I would like you to take into consideration that since this incident happened, he has been compliant with anything that they have asked him to do. He has taken initiative to work with his physician in getting on a good medication regimen to help with his multiple mental health diagnoses. I know when he comes in front of, the investigators, that it is very hard for him to articulate how he feels. He has a very flat affect, which makes him seem, I don't know how to describe it. It just makes him seem like he's not. I don't know how to explain it correctly to make you understand. But he had, during his confinement at home, we have had multiple discussions regarding his behavior, his future, the things that he's done, the chances that he's had, etc. And he does not, I can say just from talking to him myself, that he does not want to continue to come in front of the court and continue to, he doesn't want to spend his life in jail. He doesn't want to, he wants to have a normal life. He wants to go to school, get an education, start a career, and that kind of thing. He's made it, he's gonna, depending on what happens here today, he's going to Warren County Career Center here in a couple of weeks, depending obviously on the outcome today, to talk with several instructors there to determine if there's a program at the Career Center that he could take. He has never set out to hurt anybody. He knows that what he did is wrong. But he's made changes to abide by the GPS monitoring, the probation, even prior to being charged. You know, he followed like the guidelines that he was supposed to follow. So I would just like you to take all of that into consideration. When you make your decision on whether to, however you decide to, the punitive aspect of this.
Thank you. Anything else?
We have submitted a couple of letters to the court, including an apology letter to the victim. In addition to that, I would point out that Isaiah, while it may be in somewhat unknown exactly what his mental health issues are, I think he does have some significant mental health issues that have affected not only this incident, but obviously his prior record over in juvenile court. And obviously we're not looking to downplay that at all. He has not been very cooperative with the court system in the past. But I think it's important to note in the year and a half since this incident occurred, he has made some significant changes. He has not been back in court for anything else since that time. He's been compliant with the GPS monitoring. I know the court has concerns about his marijuana use, but he's actively tried to address that. It seems like the levels have been consistently going down, even if it's not completely out of the system at this time. I agree with Mother, what she was trying to say about his affect. I mean, he does come across as kind of nonchalant, not caring about the situation. I don't think that's true. I think he just struggles to express that verbally. And he does come across, in my experience with him, much younger than his age, not as mature as you would expect. And I think that is attributable to his ongoing mental health issues. I think it's a positive that he has removed himself away from Franklin and the kids that he was running with over there. I think that's had a large impact on him staying out of trouble in the past year and a half. So it seems like he's making some good choices here. He's 18 years old. Sorry, Your Honor.
It's all right. Go ahead.
He's 18 years old. And obviously this is his first time here over in common pleas court. I do think that he can benefit from the opportunities and things that this court can provide to get his life on track now, so we don't see him back here again and again and again like he did over in juvenile court. And again, as I discussed in chambers, Your Honor, my concern is sending him to prison at this time. It's not going to be a good outcome for him. So I do request that the court consider placing him on probation. He's going to comply with whatever you tell him to do. And hopefully he can move on from this and make something of himself.
Did he test today?
I didn't get an email, but.
I didn't either.
I believe he did test positive for marijuana this morning, or that's what they told him at least. Again, I don't know what the level was, but
Well, they wouldn't know the level until they send it out for confirmation. All right. Anything else?
Nothing else, Your Honor.
Mr. Buchanan, is there anything you'd like to say before I sentence you?
Yes, I would like to say that I am very remorseful for everything that's happened, and I got onto some new medicine to start taking.
For what?
My anger, my ADHD, and just to help stabilize myself.
You don't take medicine for your anger. What's the medication prescribed for? What's the diagnosis that it's prescribed for?
I'm not sure my exact diagnosis, sir.
Yes, ma'am.
He is on Prozac. It's an antipsychotic. It helps with, he's also talked to his physician about a mood stabilizer. He has been on these medications off and on for years. He just has really bad side effects to those. So they also have talked to him that if this doesn't work, that there are other medications that he can take. He has several diagnoses. He has generalized anxiety disorder, PTSD. He has social pragmatic communication disorder, which is Asperger's, just it's a different name. So he does have several diagnoses that he is medicated for.
According to the court assessment, he has been diagnosed with depression.
Oppositional ADHD and oppositional defiance.
That's not included in the assessment.
We explained all of those to her.
Well, I know you explained it. Was there any documentation provided of any of these diagnoses? Because this assessment was done, I don't have a date on it, but it says he's depressive disorder, attention deficit hyperactivity disorder, cannabis use disorder. That's the extent of the diagnosis.
Juvenile court was provided with his medical records.
Juvenile court provided us with nothing, ma'am. Juvenile court didn't even provide us with any of his infractions that were requested while he was in juvenile detention.
Okay.
We got nothing from juvenile court, although it was requested.
Okay, because she said was going to request that, and that's why I did not provide his, because she said she was going to request that.
All right.
But
Go
he
ahead.
does have several mental health diagnoses, sir.
Just for the record, the Tepe House assessment was conducted on November 14th of 2025. He was diagnosed with major depressive disorder, attention deficit hyperactivity disorder, and cannabis use disorder. The diagnosis that he provided pre-trial was ADHD, oppositional defiance disorder, intermittent explosive disorder, PTSD, and social pragmatic communication disorder. All of those diagnoses were self-reported, and we do not have any verifying documents at this time.
All right, go ahead, Mr. Buchanan. What else do you want me to know?
And I'm also looking into furthering my education.
Did you complete your high school education?
Yes, sir, I did.
Okay, go ahead.
And I was looking to go to the Career Center. I've also reached out to other schools. And also, like my mom mentioned, I contacted a Army recruiter. I would like to go and talk to them and see if maybe I could get into that. And any type of programs or anything that you sentence me to, I'm going to work them. I'm going to do everything as you say. And I just apologize and I'm sorry. And I would ask for another chance, please.
How many chances do we have to give you before you kill somebody? I'm looking at your record, 2018. That means you would have been about what? 14, 13, 12. You're 19 now?
Yes, sir.
7 years ago, you would have been 12 years old. You got your first conviction for assault. Who did you assault when you were 12?
It was a mutual fight at school.
2019, assault. Who did you assault then?
It was also a thing at school.
2021, violation of a court order. 2021, failure to comply with the order of a police officer, felony of the 3rd degree. You know, that's a prison sentence in this court. 2021, violation of a court order. 2021, violation of a court order. 2022, violation of a court order.
Yes,
2023, aggravated menacing. 2024, criminal mischief, criminal damaging. 2024, criminal mischief.
Yes, sir.
You have 3 offenses of violence on your record right now. This is 4. This is your 4th offense of violence.
And I understand that, and I'm looking to better myself. I don't want to live how I did in the past. And I'm sorry. I promise I can do anything, any type of program.
Most people are sorry when they're standing here at this point of the proceedings.
I understand.
I mean, all right, the court's considered the statements made here today, the pre-sentence investigation. The court has reviewed the letters that have been submitted by the defendant, the purposes and the principles of sentencing, the relevance, seriousness, and recidivism factors. Mr. Buchanan, I have serious concerns for you. And for some reason, and I understand this flat effect that you may present yourself with, but I think this goes much deeper than this. You can't blame violence on just the mental health conditions that you have described here today. That's not the cause of you hurting somebody seriously. I'm sorry?
I said, yes, sir.
Okay. I don't need you to respond yet. I mean, if you have something else to say, I'll give you an opportunity. So you need to say it now, because once I get started, I don't want to be interrupted.
I'm sorry.
Go ahead. Is there something else you want me to know? But I do think that our juvenile court system, I know that there are limitations on what they can do, but this is no longer juvenile court, and there are serious consequences. Anytime you make a choice in your life, make a bad choice, there's going to be bad consequences. I don't think that you've taken this as seriously as I would have liked. When you were confronted about the marijuana use, and you and I have had this discussion, your response was, well, juvenile court approved your medical marijuana. I don't know what the benefits of marijuana are. I truly don't. I don't allow marijuana on my docket. I think it's harmful, especially someone of your young age, where your brain is still developing to some extent. It does nothing but harm you. But I don't think that you have taken this as seriously as you want me to believe. And I do find today that you are not amenable to community control. So I am going to order you to serve a prison sentence, a minimum term sentence of 3 years, maximum term sentence of 4.5 years. The court does find that prison is necessary to fulfill the purposes and principles of sentence, including punishment, deterrence, and protection of the public. You have 0 days jail time credit at this time. There's a restitution owed of $11,277.75 to Joshua Krasik. That is ordered to be paid joint and severally with your co-defendants. You're also subject to a mandatory period of post-release control, which means upon your release from prison, the Adult Parole Authority will supervise you for a minimum term of 18 months up to 3 years. If you violate that supervision, you can be returned to prison for up to 1/2 of this court's original minimum term sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. It's possible for you to earn good time credit against your minimum term sentence of 5 to 15%. For good behavior, the court has a right to deny your good time credit. A hearing would be held to make that determination. Regardless of whether you receive good time credit, you will be released when you finish your minimum term unless the Department of Corrections determines that you must remain in prison for bad conduct. The court is not involved in that decision. If you're not released when your minimum term ends, you will serve an additional specified period of time, and given a new release date, you will serve until that date unless you are again denied release. This process would repeat until you are released or you finish your maximum term. Now, before I give you your right of appeal, I want to give you some hope, because it's not my intention to ruin your life. Your decision has caused you a major setback in your life. I will tell you right now that I will consider you for judicial release, and I will release you from prison after a 6-month period in prison. So after 6 months, your attorney will file, you can contact Mr. Aldridge, and he'll file a motion for judicial release. The conditions and what I'm looking at is that you've complied with all the terms and conditions of your confinement, which means you follow the rules. You show me that you can follow the rules. And then after 6 months, if you've done that, I will release you and put you on community control at that time. You understand me?
Yes.
I want to give you some hope. I'm not here to ruin your life, but you need to understand that when you hurt somebody as seriously as you did in this case, and you've done it in the past, you've had prior convictions for assault, that there are serious consequences now. You are no longer in juvenile court. Now, you do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Mr. Hardman, is there anything else?
No, Your Honor.
Nothing else?
You understand that you have 6 months. Behave yourself, and I will see you back here in 6 months. Okay? All right. Your bond is revoked. At this time, there's a deputy standing behind you. You're remanded into the custody of the Warren County Sheriffs for transport to the Department of Corrections.
Your Honor, can
Yes,
I
sir.
also say one more thing?
I'm sorry?
Can I say one more thing?
Yes, sir.
I'm not trying to act like I'm not remorseful for this situation. I don't want you to think that I'm trying to say my diagnoses are why I did this. I'm very remorseful. And like I said, I'm more willing to do anything. And with this prison time, I'm going to show you that, sir.
Okay.
And
I look forward to seeing you in 6 months. Then. Okay?
Sir.
Good luck.
can I please give my mom?
That's up to the deputies at this point.
All right, does he need?
Has to be hot for us.
Does NCCMH require any additional orders?
No.
All right, Dylan, do you understand the ongoing nature of that continuing order?
So pretty much if I screw up, I go for 90 days.
No, that's not a given. That's the maximum. I just have to say what the maximum amount is. So yeah, I'm not guaranteeing that you have to go to the hospital for 90 days. The doctors will see how you're coping, and if it's necessary, you can be hospitalized for up to 90 days, but only if it's necessary. So we're not trying to just stick you in a hospital someplace and keep you there. So we want you to be out. We want you to be enjoying your life. We want you to be safe. We want you to be doing well with your mental health. And as long as you're doing all of that, then you don't need to be hospitalized. You just need to keep doing what the doctors are asking you to do to maintain that mental health. And if for some reason it slips off the rails and you can't maintain your mental health, then they'll do what is necessary to bring it back and put it in place. And if that takes hospitalization for a little while, that's what it takes. But we're not going to mandate anything like that. Is that all right with you?
Yep, that's the only real question I had. I'm okay with everything else.
Good.
I just didn't understand that part.
Yeah, no, I certainly can. Yeah, my quick statement was a little frightening, so I apologize for that. So I just want to make sure. Yeah, no, we're good. We're good for that. All right. I will sign that order today, and that will be all. Thank you all very much. Appreciate your time.
Yes, sir. Thank you.
Thank you.
What time is it?
All right, the next matter is in regard to Mason Laws. That's file 25-11247-DD. Who we have present for that case? Ms. Hansel, can you place your appearance on the record, please?
Yes, Donna Hansel on behalf of Mason Laws.
And who do we have from CMH? Ms. Moore? Can I just have you put your name on the record, please?
Yes, I'm sorry. I'm not on this case.
Not on this case? All right, thank you.
Yes.
Who else do we have on this case, please?
I'm Mason's dad. My name is Tim. This is Mason's mom, Tanya, and Mason is right here.
Hi, Mason. How are you today?
I'm good.
I'm glad to hear that. Thank you for being here today. All right. We are here on a petition for the appointment of a guardian for Mason. I believe that Mr. Laws, Timothy Laws, is the petitioner for that. Mr. Laws, let me put you under oath while we do this. Do you raise your right hand, please? Do you swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right. Thank you very much, sir. Why don't you tell me the reason that you believe that Mason needs a guardian?
Well, Mason was born with trisomy 21. He has Down syndrome. He needs help making life decisions, impacting his safety and well-being, financial.
All right. And how old is Mason now?
17.
He's about to turn 18 on his next birthday, I assume?
Yes.
When is that?
January 24th.
So coming up pretty quickly now. So you and mom have been helping Mason throughout his entire life. Is that correct?
That's correct.
You've been making all of the financial and medical and housing and all those other kinds of decisions for him and helping him through that process?
Yes.
And now your concern is once he turns 18, he would be an adult and he's going to need some assistance from you in a similar manner as he continues on through adulthood. Would that be fair to say?
That is correct.
All right. And you've given me a very long name, the technical name for Down syndrome. Where did you get that information from?
From the internet and just being a parent of someone with Down syndrome.
And I assume that you've had some contact with his doctors in the past?
We have.
And they have confirmed for you that he has Down syndrome?
Yes.
And that is a lifelong diagnosis. Is that your understanding?
That is correct.
All right. So he's had this for all of his life, and he will likely have this for all of his life. And is there any likelihood that his functioning is going to be substantially greater anytime in the future?
Not substantially, no.
All right. And because of that condition and the length of its likely prognosis, you're asking the court to have you be able to give decision-making for financial decisions, medical, legal, residence, and matters of personal safety for Mason, just as you have while he was a minor. Is that also correct?
That is correct.
All right. And you believe that without that, he would be subject to potential of serious physical or emotional harm because of his inability to make those kinds of decisions on his own and by himself?
I do.
All right. Let me see if there's any other questions that I have for you. Is there any other information that you think that I should be aware of at this point?
No, I think that's about it. I think you have an understanding that he has special needs and that need to be looked after.
All right, thank you very much. I'm going to ask just one really long, kind of complicated question because it has all of the statutory language in it that comes with making a decision that Mason is what's called a developmentally delayed or disabled individual. So let me just kind of spit it out there and see if you agree with it at the end.
Okay.
Is it your understanding that Mason has a developmental disability which is described as a severe chronic condition that meets all of the following conditions? It is attributable to a mental or physical impairment. It was manifested before he was 22 years of age. It is likely to continue indefinitely, and it results in a substantial functional limitation in major life activities, including self-care, economic self-sufficiency, receptive and expressive language, self-direction, learning, and capacity for individual living. Do you believe all of that to be true?
I do believe all that to be true.
All right, thank you very much. And again, I apologize for the long
No
question. It just meets the statutory definition, and I want to make sure we had that in the record. All right, it does appear to me that Mason is in really, really good hands and has been for his entire life, and that a guardianship is going to be necessary for him to continue to be able to be in those good hands, and for the reasons that we've indicated on the record. Will find Mr. Laws and Mrs. Laws, do you want to be co-guardians? Do you want to have one be the first and one be the standby, or how would you like to do that?
Co is fine.
All right. We can do that. Let me just get the paperwork out here. What I'm going to sign today is a fine. I'll make a finding that is necessary and appropriate. I'm going to sign an order for that, and then we're going to send you what is called a form called Letters of Guardianship. That is the form that you can give to whatever agency or corporation or whatever that you're dealing with to make sure that you can show them that you can make decisions on Mason's behalf. So if anybody has any questions, that's kind of like your ticket to get where you need to go for that. So I will make a decision that Mason is totally without capacity to care for his person and estate as to the following areas: financial decisions, medical, legal, residency, and matters of personal safety. And we will appoint Timothy and Tanya. Tanya, that's spelled Tonia.
Yes.
All right, great. I have a wife with the same name, but spelled much differently. So I wanted to make sure I got that correctly. Right. And as will be appointed as what is called the plenary or full guardians of the individual and the estate. And we would require you, once you get this paperwork, we'll send you a form. It's called an acceptance. That's basically just saying I agree to do what the court has ordered me to do. That's just, we need to have that back. So if you'd sign that and send it back into the court, I'd appreciate that.
Okay.
Do either of you have any additional questions for me today?
I don't think so.
No.
All right. Well, Mason, it was really good to meet you. I'm really glad that your mom and dad are taking good care of you, and they're going to be able to continue to do that for a really long time now. We typically will set a review hearing in about 5 years. And we'll send you some information as to how you send us some reports and make sure that things are going well, so I can kind of review that over time. All right?
Okay.
Thank you all very much. That's all for today.
All right.
You guys have a good day.
You too. Calvin Jones, and then the most important one, Josephine Watts.
Yes.
You're welcome.
Morning,
Good morning. Your names?
Josephine Watson.
Kevin Jones.
All right, very good. And where are we on this?
Well, Your Honor, we had an opportunity to speak, and I have actually agreed to dismiss the case on the condition that they pay $40.89 today, which they are going to do after court.
I
So,
don't know if I can accept that.
Or you just want to see us back again? Because the holiday's coming up.
Okay,
For a
you
good
know what? You're right. One of you I want to see back. Guess so the case is they're gonna do that today.
correct. It's going to be on a regular dismissal form. I'll put in the further orders, $40.89 to be paid today. So,
Is that good for you folks?
yes, sir. A very Merry Christmas.
All right.
Good
Did you
holiday.
guys and I realized what the issue was and why we set this. Did you get all of the questions resolved?
Yes, we did.
Did you?
Yeah.
I'm very glad to hear that. I knew that if people sat down and talked, this was one that if people sat down and talked, kind of get through it. And I hope, I guess, because you guys took great offense to, and I understood it. You took great offense to, you pay your things, just let us know, we'll take care of it, kind of thing. And so,
Yeah.
but I don't think, I did get the impression, I don't think anybody was trying to insult you or anything like that. I think it was just what happens in life regarding communication, right?
Definitely.
All right, fantastic. Then I will mark this as dismissed. You guys are going to pay that. I'll get the dismissal paperwork all set. You guys have a wonderful, wonderful, blessed holiday, please.
Same to you.
Sir.
All right.
Good to see you again.
Good to see you.
All
Good
of
to
you
see
take care and have a good holiday.
And I just pick on you, right? I like you. I'm just picking on you.
Oh, that's fine. Yeah.
What'd you say?
Next time you see me, I'm gonna be like, hi.
Hi, there you go. Okay. All right. You guys take care.
Take care, you
You
too.
too.
Thank you.
bye, guys.
You're gonna send us a copy of James Hall.
You will get Judge, will they get a copy of the dismissal in the mail? Do you guys usually?
Yes, usually, I think it's usually sent out, isn't it?
It is.
And we'll double check and make sure
Okay.
that it's sent to you, okay?
All right, thank
Do we have an email address?
Okay, thank you.
Oh, you're welcome.
Do we have an email address for you guys? I'll do this for you.
Yes, I do.
You
want me to?
So why don't we get the email and then once I sign it, I'll email it to you,
Okay.
okay? And then maybe I won't. And then that way they have to come back down and see me.
I tried to just fill one out while I was here, but they said they didn't have any blank forms. So I was just gonna do it right here, but they said no, so. I said, that's okay, I'll just do it at the office.
Give it to you. All right, you guys take care.
All right.
See ya.
Yep. We're a court without court forms. Sorry, my bad. Court just called the case of Arbor Woods versus Michelle. Bless you. Michelle Ruillo. Is it? I think I'm pronouncing that correct.
Brianna Kingsley appearing on behalf of the plaintiff, Your Honor.
Good morning, Your Honor.
Good morning. How are you doing?
I'm good, thanks. How are you?
I think I'm okay. I never know. So this, I check myself at the end of the day and I say, okay, I'm good. All right. Your name?
Michelle Ferrell.
All right. And who's that with you?
Mandy DeBono.
Hi, Your Honor.
Hello. I kind of knew that. But anyway. All right. What are we doing on this case?
Same with this matter, Your Honor. I've agreed to dismiss this case on the condition that Ms. Ferrullo is going to pay $53.66. Based on her income restrictions, I've agreed to extend it out between 2 payments of January and February rent. So she's going to pay $26.83 with her January rent and $26.83 with her February rent.
With January and February rent.
Correct.
Right, okay. And how are we gonna do this? We're not gonna do the whole conditional dismissal thing.
No, it'll be a straight dismissal. I'm just.
It'd be a straight dismissal. She's just agreeing to
Yes.
do that, and that's a condition.
Yes, correct. It's not being waived. She's agreed to pay it on her own, but rather than enter a judgment or a conditional dismissal, I believe a dismissal is appropriate.
All right, is that acceptable to you?
Yes, Your Honor.
Anything else you want to tell me?
Have a good Christmas.
Well, thank you for that, and you do the same.
Thank you.
Okay, you guys take care of each other, please.
Thanks.
All right, I'll take care of
In
the.
that case, it's dismissed along those terms.
Okay.
Is that it for us for court stands in recess?
Thank you.
And you have a blessed holiday. I doubt I'll see you.
Martinez with her experience with him, but he's been extremely vocal in a not very nice way here in the courtroom. I just feel like at this point, we would ask that his community control be revoked and he serve out a prison sentence.
All right, thank you. Mr. Gibbs.
Yes, Your Honor. On behalf of Brandon, he definitely has some significant mental health issues that he has dealt with for some time. I've had conversations with his mother to confirm that as well. In my discussions with him leading up to this hearing, he admits, he says, you know, he wigged out. He just wasn't in a good mental place of understanding what he's doing or where he's going. Now he will come through those moments of mental issue and mental health issue. And even to the point of while he was out this last time, he obtained a job at Taco Bell and was trying to take some positive steps to build his life and get on track. But obviously recognizes that what he's done is wrong. We would respectfully request the court to consider continuing with community control, as I don't believe that punitive sanction would be the most appropriate fit given his severe mental health issues. Obviously, we defer to the discretion of the court.
Thank you. Mr. Staggs, is there anything you'd like to say, sir?
He pretty much got all of it, sir. So I don't have nothing else to say, sir.
Is he getting the treatment he needs?
He did complete a residential treatment program that addressed his mental health along with substance use. His Brandon Staggs, his drug of choice is alcohol and marijuana that he's made me aware of. Those, for the most part, have been at bay. However, when he's been out, he has used both alcohol and marijuana. As far as his mental health, I have a diagnosis of borderline personality disorder. Unfortunately, there's no medication that addresses this. This indicates that there's significant behavioral problems that Mr. Staggs is experiencing that can be addressed on supervision. However, he, since being placed on probation with me, is only willing to do things his way and is unwilling to listen to probation's authority.
Okay, thank you. You can figure out that your behavior is determines whether or not you're in jail, prison, or out.
Yes, sir.
So what can you do?
I don't know. I know I need help. The place I was staying at when I got picked up by the police, they were gonna help me get into therapy and help me, like if I needed to go to AA or NA, they would provide transportation. And like he said, I had gotten a job. So I was getting back up, like taking steps to get back on my feet, but I know it wasn't in the right way to do it because I had gotten a warrant for my arrest because I was out technically on the run. But they were going to help me get into therapy and everything. They recommended a couple places up in Washington Courthouse, and I don't know. That was my steps to try again to get back on my feet, even though it wasn't in the right way to do it.
What's his jail credit? 181?
He has 198 days as of today.
Okay, and 17 or 18 of those on this case? I mean, on this violation.
I did not calculate that, I'm sorry.
I think I've been here for like a week and a half-ish.
How long have you been in jail on this?
This time it's like a week and a half or so.
Okay. All right. Well, continue him on community control, impose a sanction of 90 days in Warren County Jail. And when he gets out, he needs to continue his therapy, his treatment. If he doesn't, then we've got 18 months that you can serve.
Yes, sir.
Less 90 plus 180, 270. So basically, 270 is 9. So you got 9 more months you can serve if you're going to do this, if you're going to continue to behave this way and not get the help you need. I understand it's like being shot in the foot with this registration requirement. It's hard to find a place to live.
It's very difficult.
Yeah. But there were people who were willing to help you.
Yes, sir.
All right, that's all.
Thank you.
Yeah, just a question. If you're sentenced him to 90 days, how much jail time credit are you giving him for that?
90 additional days.
90, oh, okay,
Yes.
90 on top of the one.
No, I'm sorry. 90 days effective the date that he came in on this violation.
Okay, so that was, sorry.
I would have to go back into my notes.
Trying to think. I'll have to look that up then.
While she's looking that up, I did want to ask for clarification. He's been assessed at a pretty high level of care. So when you say continue therapy and treatment, are you talking about outpatient treatment, residential treatment?
Whatever his assessment, when you say a high level, are they recommending residential?
Well, he was assessed for a CBCF and then he signed out of the CBCF and then went on the run.
Okay.
So I can have a reassessment conducted while he's in the jail, although most likely it's going to come back at some type of residential treatment.
Well, if that's the case, that's what it'll be, whatever his assessment says.
Okay.
I only gave him 90 days, so if he can't get in some kind of treatment, then his 90 days is up. He's going to have to get in it when he gets out.
Okay.
Or he's going to be back in here again. All right, that's all.
I'll have to look up that date. I'll have to call the jail to get that date.
So what I can do is when I go into my office,
And the court imposed some other conditions, which Mr. Green, I understand, has complied with. Now we're just waiting for sentencing. The recommendation to close without improvement. We're asking the court, if the court's going to close it, to be with improvement or keep them on probation.
Ms. Grasso. So we had given him the time to take care of his license and anything that he had going on and comply with for the 30 days due to his circumstances in his life, which is why he had absconded for so long.
What were the circumstances?
It involved his child.
His child passing away, and he was going from one address to another.
Okay, so the violation, so I see we had
They're the same violations though. I just said, the last one I said, hold violation hearing, convert bond to cash, apply bond to balance, and hold violation hearing in abeyance. So we just didn't do, did we actually adjourn it?
Yeah,
Okay.
yeah, we set it for today. As long as he was done with everything, then we were gonna close it.
And this is the only thing on his record? Is this your only? What happened with the case out of Wixom? Wait. 10/16/24. So this is the case. That doesn't make any sense. Wayne County Prosecutor's Office, but it was.
Counsel, Mr. Helbling, Ms. Nicholson, on behalf of the state of Ohio, we're here at the request of the defendant for a bond review. Mr. Helbling, you wish to be heard?
I'm sorry.
You wish to be heard on the issue of the bond?
Yes, Judge. I'm sorry. I'm adjusting my hearing. We had filed a motion for bond, Your Honor. I have had a chance to speak with Mr. Jones, and this case, the court already knows. We discussed it in chambers and stuff, but I believe that Mr. Jones would not be a flight risk or anything of that nature. I think that he's learned a great lesson from this trial. He's very humbled by it, and we would respectfully request consideration on letting him out. If the court decides to put an electronic monitor device on him for a certain period of time, maybe not forever, but until maybe sentencing or something, we understand that. But we would just respectfully request that. I hadn't had a chance to explain that. I think he knows that he has an interview with that Talbert House issue.
We'll reschedule that.
I'm sorry?
We'll have to reschedule that.
Oh, okay. I was going to suggest if we know where it's going to be, he will be there.
We'll get him information. That's all right.
Okay.
Anything from the state?
Your Honor, we did reach out to the victims for their position. Sergeant Bush is just concerned based on the defendant's lack of regard for any authority and his display of reckless behavior. Obviously, this occurred in a public place. The state will also note that this does seem to be a pattern of escalating behavior. This is not the first incident the defendant has had with the Springboro Police Department. If the court is inclined to release him, we would ask that the court put down an order that he surrender all weapons. I understand that by law, he is no longer allowed to possess based on his conviction. However, he is known to carry firearms and knives in public. So we would just ask for that order moving forward.
Okay. Mr. Jones, the court obviously did sit through the trial, so I'm much more aware today of what the allegation was, and now it's been you now have a felony conviction.
Yes, sir.
So again, the pre-trial, obviously I don't know much about the case, but I do have a better understanding now. But I am going to release you today on your own recognizance. I'm going to place you on electronically monitored house arrest. Do you work, sir? Do you have a job?
I have been helping a friend get a business up and going, but it's a hydro seeding business, so it's more spring, summer, fall.
All right, so I'm going to place you on electronically monitored house arrest. I am going to order you to surrender all firearms. At this point in time, you are prohibited from having firearms, but it's also now a court order. So the Talbert House assessment is scheduled for tomorrow at the jail. I'm going to have you, when you're released this morning, I want you to come back over to this building and go back to court services, and then they'll be aware of what's going on. And just let's get the Talbert House assessment rescheduled. You have the packet for the pretrial services interview. Go ahead and complete that, and they'll schedule that interview and get all that stuff up and running. But you're ordered to comply with that pre-sentence investigation process. Okay. I am going to order you to have no contact with Larry Bush, and I'm going to issue that order because he's a private citizen now. Yes, he is not a police officer. I don't know about let's do this. Where do you live?
6440 Widener Road.
You live in Springboro, in the
It's
city?
Clear Creek Township.
Okay. I am going to trespass you from the city of Springboro's municipal building. Okay.
Okay.
You're not to be there because you're not a resident of Springboro. So you don't have, there's no court dates or anything. You have to appear there, right?
No, sir.
Okay. So I'm going to I don't want you in that building. Let's just to be safe. And then obviously if you have an issue that you need the police, you can call Clear Creek
Yes.
and they'll respond for you. Okay. So I'm going to trespass you from this Springboro City building. And at this point in time, then again, with regard to any other orders for your sentence, I will wait and get the pre-sentence investigation so I get more information. Now, I know we've had this discussion about the use of THC.
I'm done with it.
I'm sorry?
I'm done with it.
Okay. And just so you know, I don't allow it. I don't have the assessment yet, but if it shows any type of substance use disorder or mental health issues, then I will prohibit it. So just so you know in advance, the continued use of that would cause you to have some sort of sanction. Okay.
Yes,
You have any questions for me, sir?
No, sir.
So when you're released today, come back over to this building and check in with court services. Somebody will be over to hook you up anyway, right?
Yeah, they should. Community corrections.
But come over here and let's get the assessment and the interviews reset. Okay.
Yes, sir.
Any questions?
I don't believe so.
Anything else on behalf of the state?
No, Your Honor, thank you.
Mr. Helbling?
No.
All right, very good. I'll see everybody then at sentencing. Thank you.
Tomorrow.
Yeah.
He's
That's fine.
tomorrow, and he's the first one here for tomorrow, and he have his seat now. All right, it's Davis Scott.
Yeah.
Davis Scott?
Yeah, it's right there.
Oh.
There's not any. Well, they know there's nothing there that they don't know.
You see the offer?
No, sitting
All right. 25 CR 1366 is called the State of Texas versus Davis Scott. Is that you?
Oh, yes.
With Mr. West, your attorney, and the state's attorney is here. As you know, you were charged with a third-degree felony, which is a most disturbing case. Assault of a pregnant person. Who does that? It's rhetorical.
Okay.
Sir. You know what that means? I'm not accusing you. What kind of person does that? That's why it's treated. And it's a crime. And people commit that crime. And it carries with it up to 10 years in prison. The person who is the victim here, who is this?
That's the mother of my children.
Do you understand you cannot have any contact with this person? You do, you will be in jail. It'll be so fast. If I find out you've contacted her or someone on your behalf contacted her until we can resolve this, you will sit in jail. So they advised that Davis Scott was detained at the back of a patrol car due to him running away on foot. Guilty men flee when no man pursueth, but the righteous stand bold as a lion. You know where that's from?
No.
Proverbs, the holy book. Proverbs. I then made contact with other officers at the scene who advised me it was discovered Scott had a verbal altercation with his pregnant girlfriend, which escalated to a physical altercation. He began to assault her. During the assault, Scott forcibly placed his hand on her throat, impeding her breathing. Victim wished to follow filed charges, and she had visible injury to her body. I believe and do believe that Scott intentionally, knowingly, or recklessly impeded the normal breathing or circulation of the blood of the victim by applying pressure to her throat to prevent further acts of family violence. I was under arrest. And he was transported to the Jefferson County Jail. Well, that's a terrible set of allegations. Okay, so it alleges that you intentionally, knowingly, and recklessly caused bodily injury to the victim who was pregnant, and you knew that at the time of the offense. You would know, since she's your girlfriend. I guess that's your child.
Yes, Your Honor.
And you committed the offense of choking her and pulling her hair. And then it ends like all indictments against the peace and dignity of the state, signed by the grand jury foreperson. Okay, have you talked to the victim?
I have not, Judge.
I want to know if he has any contact with her. I want to know that because it would, if you call me at midnight, we'll get everybody together in court here at 2 a.m. and deal with this quickly.
Yes, sir.
But I don't want this person being influenced illegally. What are you going to do today?
Set for trial, Your Honor. I've talked to my client several times and we want to.
Have you talked to the victim at all?
There was a note, Judge, that the prosecutor before me had already talked to her. And
Why don't you do that?
Yes, sir.
I sense, I've done this long enough. I'm sensing a whiff in the wind. All right, it is to be set for trial. Okay, how about Langston Adams, Hurston Bailey?
Keith here.
Okay. How did the event turn out with your son?
Oh, fantastic.
Yeah, I would love to have been there, and I heard it was a great thing, and I'm so proud for you and your family. And it's just Langston's son, as you know, is a fabulous athlete. His mother was a very good athlete. And I'm sorry. Langston's son's mother was a very good athlete, and he has earned some extraordinary opportunities, and we're very happy and proud for Langston and his family.
At his alma mater.
At what?
At his alma mater. Charlotte Law School.
University of Houston? No, where was it?
Loyola.
Oh, Loyola in Chicago? No, New Orleans.
That city in the back.
Okay. Yeah, that's
okay.
My mother's parents are from New Orleans. My grandparents are from New Orleans. Yep, that was some great memories. So today, it says other hearing.
No,
what does that mean?
No, it's no other hearing. I had reached agreement with Daniel to refile this as a misdemeanor. And Daniel did talk to the.
What is it? What are you filing? What's it going to be?
It's to allow a plea to misdemeanor assault, which doesn't require a refile judge.
Yeah, we can do it here.
This offense.
I think it's a lesser included class A problem.
We talked about refills, what I talked to Daniel about.
I'd rather do it here. I mean,
let me double check the elements here, Judge.
Because, commit the felony aggravated assault.
Yeah, we can certainly do this.
So lesser included class A misdemeanor.
But then that would put her on felony.
What?
Like community service and like misdemeanor community service.
I don't know
what they do. That's like 60 hours. I don't want to have a felony time. That's why I was going to refile that.
Wait.
Not time, but you know what I mean.
It's clear that these notes say that the agreement is to do a class A misdemeanor assault, 2 years deferred, no fine. And I argue with Mr. Adams, this can be done with as a lesser included offense.
So the probation office, is there a difference between what they do in misdemeanor versus in felony on what? Community service?
Yeah, because Normally, Mr.
Hold on, but on community service, but if it's a misdemeanor, wouldn't we treat it as a misdemeanor? It would be treated just as it would be a misdemeanor. And if you have a problem with it, let me know and we'll modify it.
Well, then if you wouldn't mind, just because normally in misdemeanor court, and Mr. Ham used to be.
I'd rather keep it here.
The community service, that's fine, but the community service is normally like 40 to 60 hours.
Once again,
I don't want to get hit. Once
again, I reduce.
It's 80.
But I'm reducing it in a third all the time, and people still have a ton of that left, and I dispose of it and dismiss it if they've done well, and we can accommodate this here. Just what you want, that coincides with what the probation office does for normal Class A misdemeanors.
I can sign it up with.
Thank you.
And then I'm gonna put in about 80 hours.
Sure. Well, whatever it is, it's going to be whatever that's normal and consistent. Yes. I'm going to trust it. I don't know why it would be. This is the first time I've done this for 20 years. This is the first time I've heard when we reduce it, it's treated like it's a felony versus what would normally be a misdemeanor. I've never heard that. Really. I would have thought that's odd. I would have said something, but I've not heard that. And she's saying that's not the way it is.
Be good.
Okay. Then let's do it. Thank you. David Kelvis.
I believe they saying he was in federal custody, if I'm not mistaken. At least that's what I believe happened.
I believe at the last setting, he was in Harris County Jail.
Harris County. Has he walked over yet? Has he come over yet from Harris County? That's a long walk.
That's a big walk. That's a long walk.
I can check. Give me a second.
He might get he might have problems in Winnie. A lot of traffic.
It's a big traffic zone.
So today, what defendant in Harris County Jail? So what do we do? Try to get him reset it to get him back here? It's a state jail felony DWI. What's he in there for?
He's still in Harris County Jail, Judge.
I
For
believe it's an ag assault.
Yeah, the deadly weapon.
well, they're in.
We're not going to be brought back here until that's figured out.
Okay. Why don't we review it in about 6 weeks?
That's
Is
perfect.
that good? Okay. All right. Kevin Jefferson. Actually, I have an attorney, Alex Comerfield. Mr. Comerfield, is that you?
Yes, Judge.
Okay. And you're from?
Austin.
Well, welcome.
Wide drive.
How do you get here? How'd you get here? Did you take 290 or I-10?
I-10.
God bless you. 290 is the way to do it. Okay, it's
The Taylor case. All right, so there's another case that's pending right now. Is that correct?
the Wixom, I believe.
No, I mean, I see another, I'm just trying to figure out if I'm closing with improvement or without improvement.
The one in Grantham, I believe that was a driving, is it a driving class?
Oh, that's not what I'm looking at. I'm sorry. There's one out of Taylor. It says 10:15 to 24. This one is 9:18 to 24. And it says it went down to the prosecutor's office. The charging segment is that he was charged with assault with intent to do great bodily harm less than murder.
I'm not aware.
What's your date of birth?
It's come up.
And there's a. I have that there's a case pending, that there were charges brought by the prosecutor's office. Same middle name, same everything. You didn't have anything on that?
Not when I ran it.
Because this is on his lien. I mean, it's on the paperwork. It's him.
Can I take a look at it?
Yeah, can you and Mr. Gazicki come on? Ronnie, do you see if we have any warrants for him? It's a Taylor case.
We don't have any warrants for him.
We don't?
No.
Mr. Gazicki, do you see this on this, the lien report?
I'm trying to check which,
It's Mr. Smith. Smith? Did you not recognize your name? Good morning. Are you, can y'all hold it down, please? Are you Eric Gibson? And this is cause numbers 25 DCCR 1102.
Order in the court, please. Lower your voices. Thank you.
1102, 1103, 1104, and 1105, charged in 2 of those cases with sexual assault and in the other 2 with aggravated sexual assault. And Ms. DeLage, what is the announcement?
Judge, I'm still working through discovery so I'm asking for a little bit more time.
Okay.
This is a new one.
Yeah, it is. And so, Mr. Gibson, what I'll do is do a normal reset. That'll give Ms. DeLage more time to come out, go over everything she's received from the district attorney's office, so that when we come back at that next announcement, we'll see what you want to do on your case, okay? And is there anything that you're waiting on? Is there no DNA, nothing like that? Okay, perfect. So,
Everything that they have.
okay.
I just haven't gone through it.
Okay, sounds good. Thanks. She'll see you before the next court date. You can go back with the bailiff. Mr. Kimler, you have Kashawn Purdy. Sabon. Let's see.
Judge, can we hold that just for? Oh, there you go. All right,
Just on the MTRP case.
What's yours? Yeah, right.
Mr. Hoffpower gets everything now. They're spreading the love up
They're
there.
spreading it out. I see him, I get a little nervous. Right. This association. Yeah, I read that. You did. This nation's right by me. Did you get something when she was wearing a wristband and she actually just wearing it? It's all out. All right.
Good morning. Are you Kashawn Purdy? And Ms. Purdy is on probation and cause number 24, DCCR 1272 for the state jail felony offense of unauthorized use of a vehicle. And there's a new indictment in cause number 25, DCCR 1523, charged with injury to a child, elderly, or disabled individual. Mr. Kimler has filed a motion asking for a bond in that unauthorized use case that has the motion in it. Mr. Kimler, you may proceed.
Your Honor, I think she's on deferred. I've reviewed a little bit. I haven't actually gotten discovery on the new case yet, but I have reviewed some photographs that were taken by the defendant's family with injuries. I don't want to downplay it, but it appears to be sort of the minimalist type of injury. It's not, and I'll defer to Mr. Hoffpower, may have a different opinion on that. We're simply asking for a bond on the underlying motion to revoke probation to allow time to prepare to defend the injury to a child case.
I can't, hold on. Y'all, I'm having a hard time. So if you're talking about a case, for some reason, I'm having a hard time. I've got a cold and my ears are stuffy. Y'all need to step in the back. If you're not talking about a case, I need you to really be quiet.
And I'll try to
speak up, please.
And additionally, she is pregnant. I think that, and I did receive a write-up from, that was emailed coming from the jail. And to the best of my understanding, it appears she was wearing, I guess, a blue wristband to indicate that she's pregnant. There was some, I don't know, misunderstanding on the part of the jailer as to whether some other female inmate had given her the wristband. Evidently, they get extra rations or extra portions of food and their vitamins and stuff if they're pregnant. But it appears from the write-up that she actually is pregnant. So I don't know that it was a disciplinary write-up or what the purpose of the write-up is, but she certainly, other than that, hasn't had any problems to my knowledge.
All right, you want to put on some evidence with regard to her ability to pay? Would you raise your right hand the best you can? You swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you.
Ms. Purdy, the judge just wants to know your ability to pay a bond, to actually collect the funds necessary to pay a bond when you get out of jail. What's your financial situation right now?
I had got laid off back in September, but I had got another job at the end of October. So I'll be able to pay my bond.
How much do you have available now to pay a bond as far as money that's put aside to pay a bonding fee to get out?
Like 500, 600.
Okay, and then hopefully after that, you get your job and would be able to work.
Yes, sir.
Okay.
Yes, sir.
Do you have any savings or checking, money in the bank, anything like that?
No, sir.
Do you own your own residence, your own home? Do you own your own?
Rent, yes, sir.
You rent? Do you own any vehicles?
No, sir.
What about any other thing of value that you might own? Anything?
No, sir.
That's what it is.
I need to know, how many children do you have?
I have 2 and 1 on the way.
And where do they live, with you?
Yes, ma'am.
So if you make bond, where are you going to be living and with who?
At my home.
Who lives at your home?
Me, my 2 kids, and my fiance.
Did Child Protective Service get involved in this?
Yes, ma'am, they closed the case. And I was also taking anger management and parenting class also.
Through CPS?
Yes, ma'am.
But you didn't finish those because you got incarcerated?
Yes, ma'am.
Okay.
Right.
What's your relationship with Kamari?
It's my oldest. I talk to her every day. She tells me every day, she said, Mama, I'll pray.
I don't care.
Yeah, just answer the questions.
Because you're not going to be allowed to be around them if you make bond. So you got to figure something else out until I figure out what's going on with your case. So that's going to be,
With,
Who are they with now?
my mom.
Okay. So if you make a bond, then they're going to have to remain there. You're not going to be able to have unsupervised contact with them until further order of the court. Do you understand? That would be a condition of your bond.
I told her this.
Okay. Mr. Hoffpower, what's the state's position?
Judge, that was our concern, is the new offense. I disagree whether or not it was de minimis or felony court.
Well, and for the record, I am reviewing the probable cause in that case, just to get a little bit of information on what the allegations are. What else?
Simply judge that she's on felony probation and allegedly commits a felony. We'll leave to the court's discretion.
All right, so I'm going to grant the motion to set a bond in cause number 24 DCCR 1272. I'm going to set that bond at $30,000. A condition of that bond is that you have no unsupervised contact with any children, including your own, and that you complete whatever CPS is requesting that you do. So if they started classes, you need to continue with those and whatever they request of you. Do you understand?
Yes, ma'am.
All right. All right, you can go back with the bailiff.
I just set her for an announcement again.
Mm-hmm. Mr. Macon?
Yes, Your Honor.
You have Calvin Hawkins?
Yes, Your Honor. We would ask for a very short recess.
Hold on, let's get everybody up here, please.
That's just nice. Grow 6 inches.
Good morning, you're Calvin Hawkins Jr.
Yes, ma'am.
And Mr. Hawkins is charged with unlawful possession of a firearm by felon in cause number 24 DCCR 1160. And Mr. Macon, what is the announcement?
We're going to have, at this time, announced trial on the underlying case. We have a motion to set a reasonable bond on Mr. Hawkins. It's presently set at $100,000. I'm not ready to go forward.
I don't see a motion. When was that filed? And what do you mean underlying case? I only see one case. Am I missing something?
Possession of a firearm.
Right. Okay, so there's just the one case. I don't see a motion. Did you file a motion for a bond?
I've got one right there.
I don't know that our office received it, I'm not prepared.
I don't have it either.
I'll clear that up with the.
So what we'll do is I will reset it for an announcement. Once that motion comes through, if there's a date before that, we'll get it set as quickly as possible on the bonds setting. Okay, thank you. You can go back with the bailiff. What is that other attorney?
Actually, it's Kirsten Torrey. One of your parents' surnames, is it Torrey? Is that a familial name? Torrey? Is that where it came from? And you were here with Mr. Adams, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in sentence?
Yes, sir.
In summary, this indictment alleges that on or about April 2nd, 2025 in Jefferson County, Texas, you committed the first degree felony of burglary of a habitation. Do you understand what you're charged with here?
Yes.
And there is an agreement that's been reached, and the states in the indictment burglary of a habitation with the intent to commit the felony offense of aggravated assault with a deadly weapon. An agreement has been reached that the defendant would be pleading guilty to the lesser included Class A misdemeanor of assault.
Yes, sir.
Stand by. A person commits an offense of assault if the person intentionally, knowingly, or recklessly causes a bodily injury to another, or intentionally or knowingly threatens another with imminent bodily injury, or intentionally or knowingly causes physical contact with another that the person knows or should reasonably believe that other person receiving the contact would regard it as offensive or provocative. An offense is a Class A misdemeanor, except it is a felony of the third degree if other portions of elements of the crime are committed in addition. So here, everyone agrees that her actions in this lesser included Class A misdemeanor fit either subpart A, 1, 2, or 3 of section 22.01 of the Texas Penal Code, assault, Class A misdemeanor. Correct?
Yes, sure.
All right. So you're looking at up to 1 year in the county jail and or a fine of up to $4,000 can be assessed. Do you understand the punishment range, ma'am? Yes?
Yes.
Okay. An agreement's been reached where you would be pleading guilty here and placed on deferred or unadjudicated probation for 2 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You do well, and this case will be dismissed. If you fail, your probation could be revoked, and you could then be found guilty by the court and sentenced up to 1 year in the county jail. Do you understand?
Yes.
How do you plead to this, guilty or not guilty to this Class A misdemeanor?
Yes.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty of this Class A misdemeanor of assault?
Yeah.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, is submitted. Among other things, this states you are mentally competent to enter your guilty plea, which is being done freely and voluntarily. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses, such as this Class A misdemeanor. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer, Mr. Adams. All of this is true, so help you God. State's Exhibit 1. You are the record. Without objection, admitted. Pre-sentence report waived?
Yes, sir.
I'm going to follow this agreement. If nothing further, I'm going to find you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea for State's Exhibit 1 here to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to defer any finding of guilt so long as you follow the terms and conditions of probation. The probation officer is going to go over with you, which is normal and customary for this type of offense. Make sure you understand it, follow it, and at the conclusion, do well. The case is dismissed.
Oh.
Okay, if you fail, We don't want to talk about it except to know that it could be revoked. You could then be found guilty and sentenced up to 1 year in the county jail. You don't want that. Anything else to add?
That's it.
All right, then see the probation office. Good luck. Thank you.
Thank you. Thank you.
Thanks, Langston. See you, brother.
All right. All right. Thank you, Judge.
Yes, sir. Okay. Yeah, here's this. All right, let's get ready for trial. We're gonna go mute for a few minutes and prepare for the trial, which is a felony driving while intoxicated. Stand by the button.
All right, Mr. Baker is free to go back with the, I'll sign that dismissal. What about Tyree Hartley?
Rejection.
Okay, as soon as it comes through, I'll take care of that. Sentencing on Braxton Hughes.
I actually believe I got this one, but it's not a defense. Michael Portback said, he called me tonight, he never we talked to him, he goes, I just saw you on TV.
Oh, gosh.
It's been years ago. You try to make me take it, I can't make you take that. He laughed, he's a little farmer.
Good morning, are you Braxton Hughes? And this is 25 DCCR 1124. Mr. Hughes was previously in court, entered a plea of guilty to burglary of a habitation. The agreement was for a cap of 4 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Are there any additions or corrections?
Never were, Judge.
Obviously, I'm aware of some of his criminal history, others not quite so much. I would think that the 4 would probably be on the low end in your opinion, but I defer to whatever you think.
Okay, thank you. Mr. Parker, you may proceed.
Your Honor, I mean, this is, I've talked to him and I've heard some stories in my life, but I feel that he's telling the truth, not that it's a defense, but he was they're getting pulled over. He had some other guys in the car. There was drugs in the car. They took the drugs. He leaves and goes to a house that he used to know the person that lived there. He walks in, gets him something to drink and has a thermos or something like that. And then turned around and she stayed in there. He had obviously scared her and, and didn't know it. And it wasn't the person he knew that lived there. And he said, call the cops. And he walked outside and sat down and waited for the cop to show up. And that's what happened. It's not like he was going in there, to try to injure her. I don't think he walked in the wrong house and he did take the thermos or mug and it's simple as that. I think he'd like to talk to the court, Judge. And we're asking for probation, Judge.
All right, go ahead, Mr. Hughes.
Your Honor, what he said is correct. I can't say anything else. I was doing drugs about a year and a half. But I was like a lightweight. I took the drugs and was not really acting like myself. And I went and knocked on the door and went in there. I was trying to get away from the people I was with. And but long story short, after this event, I did sober up. Started going back to church with my mom. I was in for treatment at the Right Step. I tried to get into treatment there. I was doing the paperwork, trying to get help, but I was sober for a couple months out there on the streets. And I'm not really like a typical druggy type. I don't go around and commit crimes or nothing like that.
Your criminal history would say otherwise.
This has been a long time.
I understand, but be careful how you word things because you've been a criminal since 2002. You've got 1, 2, 3, 4 misdemeanors. You've got 1, 2, 3, 4, 5 felonies. Many more that you were arrested for, and obviously doing some things that you kind of got either rejected or dismissed because of pleas on other stuff. So I understand that some of those were a long time ago, but it's still not a pretty picture.
I understand that. Most of my previous crimes and stuff, they were behind addiction and stuff. But life's a journey, and I haven't, I still was battling with addiction, but not committing crimes. This, I know, with the standing here in front of you, charged with the crime, I could understand, how it's time.
Yeah, I mean, and it's at what point do you go get that help before you commit a crime? I do appreciate what you've done since the offense, Ms. Malfino.
Judge, I would definitely agree that this is an odd fact pattern, very odd. I feel sorry for the situation that he's in with his addiction, but I feel more sorry for the young lady who was scared out of her mind when he was in her house, acting probably like a complete psychotic animal with tinfoil on his head. So I don't know that probation at this juncture would be a viable option, Judge, or a good thing for the community, but I defer to whatever you think is best.
If your history had, one of the things that is sticking out is that every probation you've ever gotten has been revoked. So you've never been successful on probation. And so.
Completing the last one.
Huh?
I did complete the last one.
The last one that I see was the federal sentence where your supervised release got revoked.
I did get revocation, but I got it back out on probation and completed it.
Okay, at this time, Mr. Hughes, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, you can go back with the bailiff. And this is Ms. Malfino. I don't usually, unless this is one that I would potentially consider, reconsider at the appropriate time if you want to file a motion for shock.
Okay.
So you just,
Maybe with safety.
something like that. Let's just see, and it all depends on how he's doing in there, but you got to do it within 6 months. And I would consider it. Tyree Hartley, I'll do that one and then I got to go back. Yeah, this is yours, Ms. Malfino.
We thought it was on the 10th, I believe.
Well, he didn't show up on that day either.
Well, it was on the 8th, and yeah, and that was a Monday, and so I knew that they were both a week apart. But I assumed they were both on Tuesday. I had it in my calendar originally, but I had gotten a new phone recently, and that didn't shift over. And so once I relocated the letter from the court, I realized that I had missed the pre-trial conference.
Did you call the court? Mr. Sheriff, can I just explain why this is important and why you've wasted everyone's time and got a warrant issued? And I want you to understand this, really. One of the reasons we do final settlement conferences, one is to like see if the case can be resolved, right? And another is to see if everyone's going to show up. Because do you know the time and expense involved in calling a jury in? It's your constitutional right, and the court has no issue doing it, right? But for us to call in 30 citizens from the city and have them come in and you not show up, or the prosecutor's officer or whoever her witnesses not show up, like the expense of that, they show up, they get paid. So the city has to pay them their jury fee. They have to, these 30 people, your peers have to, how difficult is it for you to take a day off work? If you're a mom or a dad, find childcare, you know, or organize your entire day around coming in for a trial. So, I mean, do you understand that? I mean, it's not just, it's inconsiderate, one, you know, but the reason we set those days close to trial is to make sure everyone's going to show up. Because I'm not going to bring in 30 people right before the holidays and make them take a day off work and find childcare and deal with life if the defendant or the prosecutor's witnesses aren't showing up.
I apologize.
So, I mean, that's kind of, that's a big problem. And now you show up on trial date, like if someone doesn't show up at the final settlement conference, I'm not bringing a jury in. Because the likelihood statistically of someone failing to appear at their final conference and then showing up on the jury trial date is about 0, right? So now here's the problem we have now. So now, because you missed that conference, I want you to understand like the pragmatically the problems you've caused, okay? So now we had a jury trial, a pretty quick jury trial for when you received that charge, right? By the time you came in, you came to a few pre-trials, and I know you remember because I can see when I set this trial date, I told you we're months out on jury trials. So now I have to set a jury trial. We're almost to May. I mean, I'm going to set you a trial date in April. And there's no, I mean, my trial calendar is like every single day, every single Friday from now until April, I have 2, 3, 4 trials scheduled every Friday. So now, whatever the outcome of the jury, justice is delayed, either for you or for the people, because you didn't make it to that conference. I mean, I'm setting jury trials right now in April. So I'll set aside the warrant you showed up today, but I need you to understand, like, if you don't know when your court dates are, or you aren't sure, we have a phone. You can call. There are 20 clerks down there, 16 clerks that will answer your call. And there's no harm, no foul. You call and say, hey, I want to check on, make sure I don't miss this date.
Okay.
You know, I mean, because I can't, I'm one judge. I can only do, so I got heavy dockets. I have 1 day a week I can do trials. We fit this in on a Tuesday because I think it must be I don't even know how we got this set on a Tuesday, right? But I'm the next Friday I have available is the 24th of April. And I mean, I don't know what else to do. Mr. Gazicki, I have a date on Cody Maddox. That one's supposed to go, right?
No, Cody's going to be resolved.
It is, but I have the date of February 3rd.
I'm positive on that.
I can set it on February 13th on Maddox. That's the only one I have on February 13th. I'm pretty sure. I mean, we can try and set it there and just hope that one of them resolves. If not, we're at the end of April.
Okay.
All right, I'm gonna set it for February 13th, so set aside more.
Judge, I'm actually showing a couple for that day.
How many?
There's 3.
How about James Rigdon? That's you too, Mr. Gazicki, on February 27th. How many? The Gazicki Day.
I'm only showing Rigdon.
And who's that on?
James Rigdon.
It's, I have
That's
Mr.
good.
Colobus as the attorney.
Oh, that's not Gazicki, that's Colovis. Will not get that date up though, because that one will probably go on March 13th.
Timothy Keynes, there's 2. There's a Keynes and a Griffer.
Keynes is a sovereign citizen, so that will probably go. I mean, what about just April 10th? You see the problem?
Yes, my apologies.
There's Julian Covert, it's the only one.
Who's the attorney on it? Who's defense counsel?
Kuza?
All right, so I mean, when they're retained attorneys, I'm always nervous to set them. All right, here we are. So we're at 4/24. How many do I have that day? This is why I set those trial dates so early, so I can give you your constitutional right to a jury trial without.
I'm showing none so far.
All right.
April 24th.
That's the only date. Yeah, that's the first date I have.
Sure.
And this is a state case, so this will be so we need to let Ms. Sove know that that's a jury trial date too. All right. And we're gonna set a final conference right before the trial, and
Okay.
you have to show up, because if not, I cancel the jury.
Okay.
All right.
Bond will continue, yeah.
Bond will continue. Thank you.
Touch it up. Thank you, Your Honor.
Yeah.
Good morning. Are you Tyree Hartley? And Mr. Hartley, in cause number 25 DCCR 0842, you're charged with the first-degree felony offense of aggravated robbery. And that's from April 22nd of 2025. Your indictment alleges that you were previously convicted of harassment by a person in a correctional facility, a third-degree felony, August 5th of 2013. And after that was final, you were convicted of evading arrest or detention with the use of a vehicle, a third-degree felony, December 21st of 2022. And then again, an evading arrest or detention with a vehicle, November 13th of 2023. And what that means is that if you go to trial and you're found guilty, you would be considered a habitual offender, and your minimum punishment would be 25 years in prison up to 99 years or life. Do you understand? Answer out loud, please, for me. Thank you. And I have here on the tablet a plea bargain rejection that has your signature with Mr. Parker's that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to waive that enhancement for habitual for a 20-year sentence in prison. You have every right to reject that. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plead guilty. And do you understand all of that? And do you want to reject that offer and go to trial? And is there any reason to believe that that offer would change?
No, Judge, it will go substantially.
So I want to make sure you understand, I don't want to accept that offer after today either, okay? And so if you change your mind, you can plea open to the court or to something else, but it won't be to that, all right? So I will put your case on the trial docket. Mr. Parker's been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, so Mr. Parker, you're released. We will appoint someone today. They should be out to see you very soon to begin preparation for trial, okay? You can go back with the bailiff. All right, everybody, I have to take
Is that okay?
Yeah, yep,
Yeah.
that works, Mr. Zinsmeister.
And good luck, Ms. Walton.
Thank you. Happy holidays.
You
Same
too.
here, man. Yep, bye now. Bye. Overtree versus Chastity Wright. Chastity Wright.
Yes, I'm here.
There you are, Miss Wright. Did you apply for rental assistance?
I didn't apply for rental assistance. I actually have been incarcerated, so I have just deposited my work checks into a new bank account. I'm just waiting for it here, and I can pay those behind payments. So that's why I missed the first court date. So I was incarcerated.
Okay. Mr. Zinsmeister, I think we can go ahead and proceed then.
Thank you, Honor. Ma'am, currently, Ms. Wright, there is due and owing $2,015.50 to pay the rent up in full through December. The ledger shows your last payment was October 24th. So it's been some time. There's $200 due there's $2,015.50 due now for rent and $200 in court costs. So we will be seeking a possession judgment in the amount of $2,015.50. And that amount would be due in full on January 2nd, 2026.
Okay, that works.
All right. So we'll put that in by hearing, Your Honor.
Yes, yep, we do hearing and then.
Good luck, ma'am.
That's right. You're all set.
Okay, thank you.
You're welcome. Bye now.
Thank you, Your Honor.
Thank you, Mr. Zinsmeister. I think that's it, huh?
All right. You have a good day, Your Honor. And if I don't talk to you sooner, have a Merry Christmas.
Same here. Thanks, Mr. Zinsmeister.
Thank you. Bye.
Bye now. How about Flushing Estates versus Melissa Spence and Gail Blondin?
I'm here. Melissa's here.
Okay. Melissa's there and
Levine for the plaintiff.
Here, Levine, it looks like it's a requested dismiss.
And Spence and Bolden were proceeding.
Oh, it's just on, somebody's got,
Sherman got this.
yeah, somebody's got it in the wrong file. Okay. Yep, that's the next one up. We'll put that in over in that one. All right, we're back on Melissa Spence and Dale Blondin. I got both of you there. Do you, either one of you want to talk to legal services?
Dale Blondin has passed away.
Oh.
They know that. I've showed them the death certificate. Don't know why he's still on there.
Okay.
When I first moved in 6 years ago, Dale always paid the rent. I made the house payment, the mortgage. And when he passed away,
Tell me a whole bunch of things yet, because I just don't want you to waive any rights you might have either.
no,
Do you wanna-
I'm not. I'm
Your
not.
Honor, if I may, if Dale Blondin is deceased, he'll be dismissed from the case. We'd like to have we'd like to have his death record in the file. If you could bring a death certificate or an obituary. And what
I have that.
you have it. So we'll dismiss Dale
Yes.
Bolden from the case and
Okay.
proceed against Miss Spence. Our request is for a possession judgment only for unpaid rent of $1,436.97 plus costs of $181 for a total redemptive amount of $1,617.97, which includes court costs and this month's rent.
Okay, ma'am, you do, again, are you going to apply for rental assistance or are you just going to
I
pay it?
have. I
Oh, you
did.
did.
I was denied, and that was through
Okay.
Job and Family Services. I reapplied, and I also got Governor Whitmer involved, and she's going to help me. She just sent me paperwork to fill out online. I have to fill it out and send it back to her. She's going to get involved with the Job and Family Services.
Okay, so Cash, from my standpoint though, then you don't want to speak with legal services, is that right?
Not
Otherwise, we're
going
going to proceed today. What, I'm sorry?
Not if we're going to go through Job and Family Services, right? For the state
Wow.
emergency. I don't
Yeah.
understand.
Right now, you're going to have to fill out a rental assistance form if you're going to do that. Okay, and I'll have to have that in the file and I can adjourn it for you that way.
Okay.
But you got to either, fill out a rental assistance verification form for me, or if you want to talk to legal services, you can do that. But other than that, we're going to just proceed what Mr. Levine wants to do. But if you're going to apply for assistance, I need you to fill out that form within 5 days. Okay.
And I
All
can
right,
come down there and do that?
Yep, you come down to it. Yep, our court, the McCree Building in Flint. And so we'll adjourn this, Mr. Levine. I guess our next date is the January 6th. January 6th.
All right.
At
And
9:30.
that's on Saginaw Street, the 630 Saginaw.
Yep, that's it.
Okay.
Yep. Okay.
Okay.
All right. Yeah, and that you're all set for today, though.
Thank you. Happy holidays, honey.
All right. Same here. Thanks.
Thank you.
Okay. Let's see. Flushing Estates versus Brett Sherman and Kenneth Sherman. This is the one that's being dismissed, I guess.
That's the one being dismissed.
Okay. Dismiss that matter. Let's see. How about Flushing Estates versus Katie Stack and Abraham Saeed?
Also dismissed. Yeah.
Okay. I'll dismiss that matter. Let's see. Flushing Estates versus Heidi Veach. Heidi Veach. Anybody? Heidi Veach? Nobody responding. Nobody on our Zoom meeting. I do have proof of service in the file plus court mailing. Mr. Levine, is it you or you got a witness? Yeah.
Well, I can, yeah. I'll go.
Okay. Do you swear from testimony you're about to give will be the truth?
Yes.
Okay. You can proceed.
Thank you. I'm familiar with the books and records. This is a non-payment of rent case. We show that the defendant owes rent of $1,093.64 plus costs of $168 for a total redemptive amount of $1,261.64. Based on the defendant's failure to appear, we'd ask a possession judgment entered by default, allowing for a writ after 10 days unless the total amount is paid in full.
Very good. We'll enter a default judgment.
Thank you.
Thank you. And let's see, how about Riverside Crossing versus Juanita or Janita Whitaker? Anybody? Whitaker, Juanita or Janita Whitaker? Nobody responding. I do have proof of service on file plus court mailing. Mr. Levine.
Did we get personal service on Miss Whitaker?
Let's see. Yeah, looks like we got personal service.
Okay, then we're requesting a possession judgment and a money judgment enter by default. The amount of unpaid rent is $1,388.93 plus cost of $223 for a total redemptive amount of $1,611.93. And a proposed judgment would allow for writ after 10 days unless the total amount is paid.
Sure. All right, very good. Ordinary default judgment.
Thank you.
Sure. Let's see, Riverside versus Maya Reblin.
Reblin case dismissed.
Perfect. I'll dismiss that matter. Riverside versus Amanda Gilbertson and Matthew Gilbertson.
Hello.
Buddy. Oh, there, Miss Gilbertson. Hi.
Hi.
Do you wish to speak with legal services?
No.
No? Have you applied for rental assistance or are you going to?
This morning I did, so I just gotta come sign your paper.
Oh, okay. Okay. So we'll adjourn your matter to January 6th at 9:30.
Okay.
And just come in and get that form filled for me, okay?
Okay, thank you.
All right, you're all set.
All right, thanks.
All right, bye now.
Bye.
Michigan 2020 Meadowbrook versus David Bollinger. David Bollinger? I see a name up there. Mr. Bollinger, just need to unmute for me.
Okay, I'm here.
There you go. Hi. Mr. Bollinger, do you wish to speak with legal services?
No.
No? Are you applying for rental assistance?
No.
No? Just want to proceed?
Yes, sir.
Okay, Mr. Levine?
Yeah, for Mr. Bollinger, we're showing unpaid rent of $1,168. And we have costs of $168. That totals $1,336. It's the present balance.
Okay.
Our request is for a possession judgment only, no money judgment. That would have to be paid in full within 10 days.
We'll do it at 11. Do it on a different day. Yeah. Okay. You're Michelle Cormier?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
Yes, ma'am.
Ms. Cormier, in clause number 25, DCCR 1446, let's see, are we going on with the prior or just the, okay. Let me, you're charged, hold on. You're charged with manslaughter from November 2nd of 2024. It's a second-degree felony. The indictment alleges you were previously convicted of burglary of a habitation, a second-degree felony, January 30th of 2013. And how do you plead to that charge? And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they've charged you with? And is that prior conviction true?
Yes, ma'am.
Okay. Sorry, it takes me a minute to get it pulled up. And cause number 25 DCCR 1447. You're charged with possession of a controlled substance, a state jail felony from October 30th of 2024. The indictment alleges you were previously convicted of possession of a controlled substance, a state jail felony, January 30th of 2013, in two different cases or three different cases on that date. And what that means in that case is that would be enhanced to a third-degree felony. Do you understand?
Yes, ma'am.
And how do you plead to that charge? And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And are those prior offenses true?
Yes, ma'am.
In each of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Radford?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And so there's no agreement, correct, in either of the cases. So I want to make sure you understand that you have an absolute right to have a jury come in and determine 2 things. The first is to determine if you're guilty or not. And then if they find you guilty in the case, you could leave your punishment up to that jury. If we go forward this way, you're leaving your punishment up to the court. And is that what you want to do? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Cormier is not competent?
No, ma'am.
All right, ma'am. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get a pre-sentence report done, and then we'll come back for that hearing. Anything that you think is important for me to know, get that information to Mr. Radford, and he will present it to me on your behalf when we come back.
Judge, we're gonna have some letters that I will submit to the court to supplement the PSI, and I will copy Mr. Coleman on those support letters.
Okay, sounds good. And if you'll just try to get those to the court that week before the hearing, that would be great. All right, thank you. You can go back with the bailiff. Yes, sir, thank you. Mr. Rojas, you have Adrian Banks. Morning. Good morning. Are we going on count 1 only?
Yes,
Or-
Judge, if we may, with the court's permission, this is basically a misdemeanor offense, but due to the nature of it, it's TDC.
Good morning. Are you Adrian Banks? And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Banks, in cause number 25 DCCR 1432, you're charged with a 3rd-degree felony offense of harassment of a public servant in count 1 of that indictment. And that is from September 1st of 2025. And how do you plead to that charge?
Guilty now.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am. I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Banks is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of, in count 1, of harassment of a public servant. Sentence you in accordance with your agreement. It was 2, right? To a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Raymond Sweet, Mr. Rojas. this may be my last one. I want to tempt it too much getting into.
Seven.
Good morning. Are you Raymond Sweet?
Yes, ma'am.
And Mr. Sweet, in cause number 25, DCCR 1531, you're charged with a first-degree felony offense of burglary of a habitation with intent to commit another felony, and that's from August 22nd of 2025. Your indictment alleges you were previously convicted of burglary of a habitation May 28th of 1987, and also burglary of a vehicle on that same date. And then after those were final, you were convicted of robbery April 20th of 1988, and also burglary on that same date as well. And then after all of those were final, you were convicted of aggravated assault of a correctional officer June 8th of 1992. What that means is that if you go to trial and you're found guilty and those prior offenses are true, the range of punishment in your case would be between 25 years and up to 99 years or life. Do you understand? And I have a plea bargain rejection here on the tablet that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 30-year term in prison. You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? I'll get that done. I do want to make sure, Mr. Smith, is there any reason to believe that there's any other evidence or that offer would change?
It's not going down.
So I want to make sure you understand that I will not accept that offer after today. If you change your mind and you want to enter a plea of guilty, then it would be to something different or open to the court. Also, so do you want to go forward with trial? Okay. Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint someone else today who could begin preparation for trial a little quicker. Is that okay with you? So, Mr. Rojas, you're released. We will appoint someone today. They should be out to see you very soon to begin preparation for trial. All right, you can go back with the bailiff. Yes, sir. Robert Felix, what are you going to do? Yeah, that's good. And then what about, we got an incompetent. Let's see, I think I can get that done maybe. Well, I hate to get in the middle of it. I feel like surely he's going to be soon. Quentin Sells, let's get him ready real quick. See if I can do that. I know. Yes. Okay. You probably do. Maybe it's okay. Yeah. I just want to have All right, are you Quentin Sells? So, Mr. Rojas, you've been appointed to represent Mr. Sells. Is there any reason to believe that the person standing before me is not Mr. Sells?
No, Your Honor.
And so I'll take judicial notice of that, as well as the court's file, including a report. Mr. Sells was evaluated for competency to stand trial by Dr. Hamza. I have received that report dated November 14th of 2025. The finding is that Mr. Sells is not competent to stand trial at this time. Is there any other evidence with regard to competency?
No, Your Honor.
Not from the state here.
Then at this time, based on that evaluation, I am going to find that Mr. Sells is not competent to stand trial. I'm going to order inpatient treatment at the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility, and then we'll await a report from that facility. He can go back with the bailiff. We're gonna get you, we're gonna get you some help, and then you can come back and take care of your case, okay? Go back with the bailiff, okay? Right there, go back, go to the back, okay? Go to the back. See who's got- Ms. Holmes, you're working on some stuff, it looks like. Let's see, got a couple on Mr. Lewis. He might be working on those. So if nothing's ready, I'm gonna go ahead and just take a break and then I'll be back in hopefully in about 15 minutes again.
Oh yeah, I'm gonna pay that next week. I tried to pay it last month and my bank messed up, which is why it's behind what it is. I was just looking at it. I don't know why my bank did, because it's not even showing up on my bank account at all, but showing up on the community portal.
Yeah.
But I just need till next week so I can pay that whole thing off.
Okay, so this will give you, it'll give you the 10 days, but honestly, it'll be a little bit past the 10-day period, but that should give you enough time then, it sounds like, so.
Okay, because my next check is supposed to be on Christmas Day, but I know it's either going to come in at between the 23rd or the 26th. So,
okay. So what I've told everybody, and just to be right up front with everybody, it's likely I'm not going to sign it till December 29th, which would be that Monday. So that gives you a little more time.
okay.
Okay.
But yeah, I'll have it paid all next week.
Okay.
Thank you.
All right.
Am I submitting this as a judgment by hearing?
Do it by hearing. Yeah. Yeah.
Thank you.
Yeah. Sure. Mr. Ballinger, will you can either pick up a copy if you need to, or we'll mail it to you. Okay.
Okay, so you guys will mail it to me?
Yeah. Yep. It'll come to you in the mail.
Okay. Now, if I get it paid next week, it'll be dismissed, right?
It doesn't get dismissed, but there won't be an eviction. No writ of eviction. You know, they're not going to order evictions. What's going to happen?
Okay.
Okay. So, you know, if you want to close the court, make sure we've closed it. I guess you could do that at some point, but that's kind of what happens.
Okay. Now, it's 1,330 something, right?
36.
36. Okay. I just want to make sure.
Yeah, sure. I absolutely understand.
All right. Thank you.
All right. You're welcome. Good luck to you.
Thanks.
Yeah.
Excuse
Bye
me,
now.
Your Honor. This is Janita Whitaker. I just got my microphone to work.
Oh, you must
I
be on
just-
one of these devices here somewhere. Mr. Levine, was that yours, Whitaker?
Yes,
Let me look here.
I guess it was, what was it, Riverside, you said?
yep, Riverside Crossing.
What did we do? Looks like we did a default judgment. Mr. Levine, make this we gotta go back on. We might as well do it right now. She's here. Ms. Whitaker, did you apply
Yes.
for rental assistance, or are you going to?
And my caseworker, it needs a paper from the court.
Caseworker needs a paper from the court. I mean,
A
usually the
judgment
son.
paper?
Okay, that's what I was gonna say. You know, they can't. If you need a judgment, we can go through it and get that to you. Makes it
Okay,
usually a little
that's what
faster,
she wants.
but I gotta tell you, by law, they can't just demand that they have the judgment to help you out. That's all. But if that's what they
Okay.
want, if you want to do that,
That's
we
what they
can.
want.
Okay. All right,
Can I
Mr.
do it by hearing
Levine,
since she's present?
sure, yeah, let's do it that
Instead of
way,
a
sure.
default?
Yeah.
Well, I need
Why
a
don't you give her the give her the figures again, just to.
Sure. We have, for Miss Whitaker, we have $1,388.93 for unpaid rent, $223 for costs, total of $1,611.93.
Okay,
It's for
Okay.
possession and for money damages.
So I'll sign that judgment. They're pretty good about getting it to me pretty quick, within an hour or so.
Okay.
I'll sign it for you. If somebody can come down or you want to pick it up, you could do that right at the courthouse.
Where
Otherwise,
do I
we
have
might-
to go?
right on Saginaw Street at 630 Saginaw Street. It's the McCree
Okay.
Building. Otherwise, we'll
Okay.
mail it to you, but it'd be faster to get it that way for you.
All right. If I can
Okay.
get somebody to take me, I'll come get it.
Sure. And if not, we'll mail it to you anyways, but that would save you some time.
Okay.
All right.
Thank you, and I'm sorry about that.
Oh, no, you're fine, Miss Whitaker. Thank you for
Thank you.
staying there. All right. Bye now.
Okay. Bye-bye.
Bye. Let's see. How about Meadowbrook versus Chandra Anne Marie Cole?
Chandra. Or the plaintiff.
It was Chandra Cole. Nobody responding. It looks like I got service by attachment plus court mailing. Mr. Levine, we can proceed.
Thank you. Requesting a possession judgment entered by default. The amount of rent to retain possession in this case is $3,054 plus cost of $168 for a total redemptive amount of $3,222, which would have to be paid within 10 days to retain possession.
Under a default judgment.
Thank you.
You're welcome. Let's see. Meadowbrook versus Marcia Cranfill. Marcia Cranfill. Nobody responding. I do have proof of service in the file plus court mailing. Mr. Levine, looks like we can proceed.
Requesting a possession judgment by default against Ms. Cranfill, reflecting the amount of rent to retain at $1,019 plus costs of $168 for a total possession judgment of $1,187. Our proposed judgment has December 26th as the writ date and requires payment in full.
Very good. Under a default judgment. And let's see, how about Meadowbrook versus Kimberly Lanham? Kimberly Lanham. Anybody? Nobody responding. I do have proof of service on file plus court mailing. What?
I'm
Lanham?
here.
Oh, there you are.
I'm
Boy,
here.
just in nick of time.
This case was supposed to be dismissed
What's your
because
name?
I paid my November rent.
Yep.
They lost the money order.
Are you
Not the money order,
Kimberly?
the cashier's check.
Are you Kimberly Proctor Lanham?
Yep, I
Okay,
am.
Okay.
Our balance is down. I'll acknowledge that a payment was made on the account and our balance is down, but we still have a balance of unpaid rent at $663 and we have court costs of $168. That's a total present balance of $831. And since
No, I paid that, the cashier's check. Heather lost that cashier's check when I put it in the box. She lost the November rent. I paid December, paid October. She lost the November rent. And I told her we could not put a stop pay on that November for 90 days. The bank won't allow it.
Listen, did you want to?
And we told her that. What?
I'm here too.
Oh, we told Heather that we couldn't put, it took 90 days to put a stop pay on that. We couldn't put a stop pay. It had not been cash and the 90 days is not up until the end of this month. So therefore, we don't have the extra money.
You're running a tracer on it right now?
We cannot do it until the end of the month. It takes 90 days. It's just like a money order, they said. Cashier's check takes 90 days. We get the cashier's check from the bank.
Can we hear from Heather at the property, or is that?
It's Caitlin.
Oh, Caitlin.
Let's you guys, rather than getting into hearing,
I talked to Heather yesterday. She said this case was supposed to be dismissed. It's a good thing I called.
No, it's not dismissed. I think it could be adjourned.
Ma'am, let's if you want to speak with legal services, we can do that. If not, we can just proceed right now, I guess.
This is bull crap. This is bull crap. They lost the money.
Hold on, ma'am. Do you want to speak with Genesee County Legal Services, or you just want to proceed? It's up to you.
Yeah, I want to speak to them because this is crap. They lost the money.
Okay. All right.
They're responsible for that check, not us.
Okay. Hold on. we'll adjourn this matter to our next date, January 6th at 9:30. And Ms. Lanham, what I need you to do on your device there, do you see there's a chat button?
No, I don't have a chat button on my device. I have an Android.
Okay, you should still have some kind of a, let me just give you their phone number. It's 810 234 2621.
2621. Okay.
Yeah, make sure you call them right when we get off here, okay?
Hold on. The phone's on the charger. I've been on phone with you guys all morning.
Okay.
I was
All
about
right.
to die.
Okay, we'll make sure you call them when
Hold
we
on.
hang up here. All right?
Let me get a phone pen. Hold on. I thought I had one in my room here. Two, three, four.
Yep, 234-2621. And area code's 810.
Okay.
All right, give them a call and then we'll see you back here January 6th, okay?
Okay.
All right.
Bye.
All right, and you, bye now. Let's see, Mr. Levine. How about Meadowbrook versus Caitlin Montgomery?
Yes, I'm here.
Montgomery, did you apply for rental assistance
Yes, I did yesterday.
yesterday?
Yeah.
Okay. Well, we adjourn your matter then to January 6th date. You got to come down and fill out a rental assistance application for me, okay?
Okay, can I go to the one on Flushing Road, or do I have to go?
Unfortunately, yep, we just moved out of there. We're closed and we're down in Flint now at that. I think it's showing up on the paperwork now, 630 Saginaw Street.
Okay, yep, I will do that.
Yeah. All right, just do that, and then we'll see you back here January 6th.
Okay, can you tell me what the balance is?
Yeah, sure. Yep, Mr. Levine.
Oh, so Miss Montgomery, we show $2,483 for rent.
Okay.
Costs are $168, and the total is $2,651 as of today.
Okay, perfect. Thank you.
All right. Good luck, ma'am. We'll see you
Thank you.
after here. All right. Bye now.
Bye.
How about Meadowbrook versus Andrea Rueda? 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 Andrea Rueda. Anybody?
For the plaintiff.
That one's being dismissed.
You want to dismiss? Right, we move to dismiss, Your Honor.
All right. I'll dismiss that matter. How about Meadowbrook versus Brandon Hammond and Hannah Frazier?
I'm here, Your Honor.
Ms. Frazier, get you there. Did you apply for rental assistance? Or are you
I'm in the
going to?
process of waiting on a response from DHS right now.
Okay. All right. We'll do the same thing. Adjourn your matter to January 6th at 9:30.
Can you tell me the total balances that I owe
Sure.
right now?
Yep.
Ms. Frazier, we're showing $1,355.03. Costs are $206. The total with costs is $1,561.03.
Okay.
Right. And ma'am, all I need you to do though is fill out a rental assistance verification form for me, okay?
Yep.
All right, do that for me, and then we'll see you back here January 6th.
Okay, thank you.
All right, you're welcome.
Bye-bye.
Bye now. Bye. Meadowbrook versus Edna Sanchez and Stephanie Peters.
Here, Your Honor.
Right down at the bottom there, Miss. Is it Miss Peters?
Yep.
Yes,
sir.
Yeah. Okay. Do you wish to speak with legal services?
No, I actually paid November. I went down there on the 5th, and I gave them $800 for November. So I'm caught up until this month, and I'm getting the rest of this month together.
Okay.
For Miss Sanchez and Peters, we're showing $905 as unpaid rent. plus cost of 206 for a total present balance of $1,111.
Peter's in. Go ahead.
Okay, so on the 5th, I went down there, paid 800, and that was towards November's rent. And then I owe like $32 more for November, and then I owe for December's rent.
Yeah, that's reflected here. That is reflected on this balance of 905.
Yeah, and I just got the paperwork for, yeah, because after I dropped off money, I was like, wait, I already paid for November, so.
And you have it all paid by the 29th?
Not with Christmas here, sir, I'm sorry. I mean, I can have some of it, partial of it.
Mr. Levine, I guess I'm making decision or what?
Yeah, that's it. We have a possession judgment enter. There's really no
Okay.
tribal issue, and there's no rental assistance. So I'd ask
Okay.
the possession judgment enter. For
Okay. Ma'am, you're working, is that right?
I just lost my job, but I've been out looking for another one.
Okay. Were you, it sounds like you were not applying for rental assistance, is that right?
Yeah, because I got denied, so I just started going out there making money on my own. So
Gotcha. Okay. All right. Boy, the best I can do is give you till the December 29th date.
for like the whole month, like can I make a little bit of a payment? Or they go for that?
Well, I don't know. I mean, the only thing I can do is whatever the amount owing is, I can do that and give you a writ of eviction date after December 29th.
Right, because as of right now, I'm up to date except for December. So it would still, I mean, I could pay some of it, but not like all of it.
No, I
If they
understand.
can go for that, yeah. But if they go for that, I can work with them. Like they worked with me before.
I guess Mr. Levine.
I would still encourage her to talk to the office and take money that she has when she's ready to pay it. But our request is for all of it by the 29th at this time.
Yeah, I have been in contact with, like I talked to her the other day and I talked to her today too, this morning to see if I have to still make the Zoom meeting or not. Because I was kind of still, like I made November payment and then I'm just owe for December, which I'm working on it. So I'm not,
Yeah.
I mean, I'm behind, but I'm not technically behind.
Yeah, ma'am, that's the best I can do. I'd stay in contact with them though, okay? That's the best I can from my end. Okay. All right, so we'll do it that way. Set an eviction date after December 29th. Okay. All right, that gives you some time to talk to them though, okay?
Okay, so if I keep in contact with them and like I make partial payments, there should be like no eviction date, right? Because
Well, I can't say it from my end. If they presented me with an order for eviction and it hasn't been paid in full, I could sign that after the 29th. But
Right.
if they don't present it to me, if they want to work with you, that's up to them.
okay, all right, so we don't have to go through you for working together.
Yeah, as long as they're working, yeah.
All right, that's cool. Yeah, they're good people, so they should. Okay.
All right. All right, we'll do it that way then. You're all set.
All right, thank you. Happy holidays.
Same to you, ma'am. Bye.
Thank you. Bye-bye.
And they may be good. I'm just not sure about Mr. Levine. That's all. How about Meadowbrook versus Dennis Jones and Leisha Jones? Anybody?
I'm here.
Up at the top. Oh, there you go, Leisha Jones. Did you want to speak with Legal Services?
No, sir.
No. Have you applied for rental assistance?
Yes, I did.
Okay, when did you do that?
I did that yesterday because I just received the paperwork.
Okay, so you just put it, okay. So we'll adjourn your matter to January 6th at same time, 9:30, okay? You got to come in and fill out that form for me though, okay? That rental assistance verification form.
Okay, and I have a request.
Okay.
My end of the paperwork shows that it's just for the month of past due month of November. Can we add December into that as well so that I don't have to
Yes.
get another one?
Mr.
Yeah,
Levine?
yeah, and we're in December, so we're adding December, and we come back on January 6th, we'll also be including January's rent on the judgment that enters January 6th. Right now, your present balance is $1,226 in rent, $206 for costs, totaling $1,432. And we'll add January into it at the next hearing, and you'll have 10 days from the next hearing to get it all taken care of.
Okay.
Thank you.
So the paperwork, just so I have this clear, the paperwork that when I come in and pick up the rental assistance in judgment, it'll state the 1432.
Well, yeah, we're not putting in a judgment right now, unless you want to do it that way. We're not doing a judgment. You'll be back here January 6th. And what Mr. Levine is saying, it'll include January's rent by that point. If you wait, if we have a hearing in January and the money's still, that's what he's saying.
You can pick up an updated ledger from the office. If you'd like to stop by the Meadowbrook office, they can give you an accounting to date.
Okay, yes, that'd be great. That way I can take that in and hopefully get that,
Sure.
1,432 taken care of. And
Good. No, that's what we want to do. Thank you.
okay, wonderful. Thank you so much.
You're welcome, ma'am. Good luck to you.
Thank you. Bye-bye.
Bye. Yep, bye now. Meadowbrook versus Juan Aguilera, Bobby Jones, and Samantha Jones.
I'm here, Your Honor.
You got Samantha right in front of me there. Miss Jones, did you want to speak with legal services?
No,
No? Do you want to, have you applied for rental assistance?
I don't think I have.
No? Well, I can't speak for you, I guess. I don't know whether you can or not, but you have a right to apply.
Okay, because what happened was I did fill out like a SER through DHS, and they had denied me on that.
Okay.
They couldn't do the full payment on that. So I had my that had paid that, or I was gonna be evicted last month at the end of last month.
Okay. So
I couldn't come up with that money of last month. So I paid my CPS worker, and she told me she had took care of that for me.
I'm sorry, she said what? She was gonna what?
He took care of that for me.
Took care of it for you, like applying for services? Is that what it was, for rental assistance?
I think so.
Okay, so what do you want me to do today then? Do you want to just proceed and get a judgment so you can take that with you, or it's up to you?
Yeah, or can you mail that, because I don't have a copy of that.
Sure, yeah. Go ahead, Mr. Levine.
Yes, right now we're at unpaid rent of $2,247.09 plus cost of $244 for a total redemptive amount of $2,491.09. It's for possession only. Require payment in full by the 26th, although I think she has until the 29th given the court schedule. And I'd be happy to submit it for entry, and then we can get it to Miss Jones so she can take it wherever she's going.
Okay, Miss Jones, anything else you want to tell me then? Is that
am I getting evicted anytime soon?
well, if it's not, the paperwork's going to tell you if you're not paid in full by December 29th, they could apply for the order to evict you. Okay.
Okay, because
That's the best I can tell you. I'm sorry.
Because I'll be out by the second weekend of January, so that's why I asked if I was going to be evicted or not.
Okay, the only thing I can tell you is if they request it at that time period, and it's not paid in full, then I would sign it from my perspective. And Mr. Levine is probably going to tell you the same thing, I'm guessing.
Yeah, you need to move sooner than that. If you're planning on moving, you got to move sooner than that, or you'll be facing an eviction.
All right, how much does it have to get paid?
2,000. Let's see, $2,491.09 is the total with December's rent and with court costs. $2,491.09 on or before December 29th. After that date, we'll be asking for an eviction.
You said December 9th?
29th.
Oh, 29th. Okay, as long as I can get that paid, that should be getting that taken care of.
Yep.
Yes.
Alrighty, I appreciate it.
Okay, man. Good luck to you.
Thank you, you too.
Bye now. Bye.
Bye.
How about Meadowbrook versus Shelby, Wasaki, Pamela Ogle, and Troy Ogle?
I'm here, Your Honor. Good morning.
Or I'm sorry,
I'm
which
Shelby.
one?
I'm Shelby.
You're Shelby.
Troy
Okay.
is next to me. Pam is sick.
Oh, boy.
I've been in contact with both Heather and Caitlin. My husband does construction, so being the winter, he got laid off. So he was paying rent. He would get his checks every weekend, or every week, and then I get paid every 2 weeks. So I will have another check this Friday. And then to be safe as well, I did fill out an SER form, and I have a tracking number for you, but I can also come down and fill out a paper.
Okay. Well, actually, the tracking number helps, but for me, you have to fill that form for me.
Right.
You do that for me. We'll just adjourn it to January 6th at 9:30. Okay.
Okay, I appreciate it.
Sure. And just come in and just fill that form out for me. Okay.
All right.
Although, Mr. Levine, do you want that tracking number? I don't know if you guys want that anymore or not. I don't know.
I don't think I need it. We can always be in touch or just keep the management in the loop.
I did have them make a copy of it, so they do have the.
Yep,
Yeah.
I have a copy of it, Jared.
But then the right people have it. We're good.
Okay.
We'll see how
All right,
this.
man. All right. So we'll see you back here January 6th. Okay.
Thank you.
All right. You're welcome. Bye.
Bye-bye.
Bye. And let's see. How about Meadowbrook versus David Sandhurst?
I'm here, Your Honor.
Mr. Sandhurst, right in the middle there. Do you wish to speak with legal services?
No.
No? Have you applied for rental assistance?
No, I never have. I did see on the beginning of the Zoom call, I did see that VA offers rental assistance. I didn't know the VA offers rental assistance, so I'm gonna give that a whirl. On top of, I just got behind. I've got into a couple accidents with $1,000 deductible, insurance deductible, so it set me back on rent, which is no biggie. But I do get paid every Friday, so a minimum payment of $500 will get paid to them every Friday. But in the meantime, I am going to fill out that paperwork
Okay,
and get rental assistance. See if I can.
Okay. So let's do this then. We'll adjourn your matter to January 6th.
Okay.
Making the payments is going to help too, but we'll adjourn it to January 6th at 9:30. And then you just have to come in and fill out that rental assistance verification form for me, okay?
Yes, sir.
If you want legal services number, you can call them too. It's up to you. If you didn't know what you had coming to you.
I don't really know how any of this works. I don't know
Okay,
what the
so I'll tell
benefit
you,
of
let me just give you the number. It's a free number to call. So, okay, it's Well, actually, probably the easiest way, why don't you do this when you pull up your chat? Can you, if you touch the chat button, that gives you that link.
Okay.
Just fill out that, it's a small little form on there. Just fill out that form and they'll contact you. That'll give them some information too, okay?
All right.
But I would, you might as well do that as long as you're doing it anyways, okay?
Yeah, absolutely. Thank you. Appreciate it.
All right, you're welcome. We'll see you back January 6th.
Sounds good.
All right.
Thanks.
Bye.
Bye.
Yep, bye. How about Meadowbrook versus Tracy Skinner? Tracy Skinner? Nobody responding. Looks like I got nobody on our Zoom meeting. I do have personal service on this plus court mailing. Mr. Levine.
Thank you. We're requesting a possession judgment against Ms. Skinner for unpaid rent of $601 plus costs of $168 for a total possession judgment of $769, which have to be paid in full by within 10 days to retain possession.
Okay, very good. Preliminary default judgment.
Thank you.
Meadowbrook versus Janice Wentz. Janice Wentz?
That one can be dismissed.
All right, we'll dismiss that matter. And I think that's the end of the roll call for you guys.
Thanks, Judge.
All right, thanks, Mr. Levine.
Sorry, my case, my phone glitched and I don't know, I had to log out and log back in. I don't know if I got called.
Are you on, who's the landlord?
Meadowbrook?
We dismissed the case for Daniels.
Okay, sorry, my phone glitched and I had to log out and log back in.
Did you pay it in full?
Yeah, my portal right now says rent balance owed is 0.
Yeah, we dismissed it. Yeah.
Okay, thank you.
Great. Perfect. Good luck, ma'am. Bye.
Thank you.
Judge.
Thanks, Mr. Levine.
Should I stick around?
Depew, Kimberly Depew, ma'am. Oh, why don't you unmute there for me?
There we go.
Mr. Depew, you gotta help me out a little bit. What are you here for?
It was for Meadowbrook. I got, because when I pay rent, I have to pay in 2 increments and it's always paid before the end of the month. And I called Caitlin yesterday and she said it was going to be dismissed, but I have contacted legal services because of things that were not being repaired.
The case was dismissed.
Okay, so ma'am, from my end right now, that their case is dismissed. So, just stay in contact with legal services, whatever you got going on with them. Okay.
Okay.
But yeah, but your case is dismissed for me. Okay.
Okay. Thank you.
All right. Bye now. And Mr. Levine, I guess hang in there for one more, maybe. I don't know. I've got a Samsung. Anybody on that Samsung?
Yes, Kimberly Wenslick, Sin.
Oh, Kimberly Wenslick? Oh, that's with Mr.
You're
Simpson.
right.
That's a different one. Yep.
Yeah, that's not mine. Okay.
Nope. I'm hopeful that's it.
Your Honor,
Take care, Judge Goggins.
You too. Thanks. Bye. Mr. Sabo?
Yeah, sure. Yeah, I understand my case got called. I had I got kicked off and I tried to get back on, and unfortunately, I believe I was in between. It was called in between.
Okay. All right. Well, that's easy to take care of that. And I've got Miss Wenslick here, it sounds like. Kimberly Wenslick?
Yes.
Okay. So I'm going to strike the dismissal I had on there. Miss Wenslick, this is termination. Did you want to speak with legal services?
Yes, I would like to.
Speak with them. Okay.
That all worked out just fine then. And cause number 20, sir, you are Jasmine Hancock. And Mr. Hancock, I'm going to go through your cases with you. Now that you've made bond, you am going to give you an opportunity and expect you to try to hire your own lawyer since you've made bond. And so let me go through these 3 cases with you since this will be considered your initial appearance. In cause number 25, DCCR 0737, you're charged with evading arrest or detention with previous convictions from April 22nd of 2025. In cause number 25, DCCR 0738, you're charged with continuous violence against the family from April 26th of 2025. And in cause number 25, DCCR 1233, you're charged with evading arrest or detention with previous convictions from August 5th of 2025. So were you out on bond and then got arrested again?
No, I had missed court because I was in the hospital and they fucked them up.
No, I'm talking about your first 2 cases are from April and then there's another evading from August.
I got incarcerated all day.
Okay. So, sorry, give me a second. It come in. Yep, it's coming. Now it is. Well, maybe.
Give it just a second. It opened the wrong one in the background, that's why. Hold on a minute.
Good morning. Are you Isaiah Brown? Will your client waive the formal reading of the indictment? Mr. Hoffpower, this is yours on Isaiah Brown. So it's a reduction to state jail.
Yes,
Okay, Mr. Brown, in cause number 25, DCCR 0356, the state has elected to proceed on the lesser offense of a state jail felony, abandoning or endangering a child with intent to return from February 9th of 2025. And how do you plead to that charge? Speak up. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? Answer out loud.
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1. No objection. It's admitted. Is there any evidence that Mr. Brown is not competent? No, Your Honor. All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that we can get a pre-sentence report done by probation. Then we'll come back at a later date for sentencing. Mr. Hoffpower, what is the state's position with regard to a bond based on the nature of this plea?
We have no position.
What is the, what's the relationship to Kinsley Segura?
Child.
This is.
It's your daughter?
No, he's not with the mother.
I'm sorry?
They have custody. I'm not sure if what kind of.
Do you have any kind of,
No, she blocked me when she had my baby. So I'm not on the birth certificate. I'm not on none of it.
so until anything happens legally with that, you cannot have any contact with your child. You understand?
Yes.
Okay. So what I'm going to do based on the nature of this plea agreement between now and sentencing is reduce your bond in your case to $1,000. If you make that bond, it's very important that the first thing you do is go to the probation department so they can start that pre-sentence report, okay? Also, a condition of that bond is that you have no contact with Kinsley Segura, okay? And then we'll see you back at sentencing. All right, you can go back with the bailiff. I don't know what's wrong with this thing. I don't think it sent it to you. It's not responding again. Now I got an unhandled exception. Because I tried to, I think I didn't send it to you, or it showed up here even after. Thank you. All right, Mr. Brewster, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what is the state's position with regard to bond reduction based on the nature of that plea agreement?
Your Honor, he has a prior successfully completed probation for deadly conduct. The situation involves an in-home argument with his adult sister where he shoved her and brandished a machete. My concern would be if he was released, where would he be awaiting sentencing?
Mr. Broussard, when you are released, whether it's on a bond or when you get this probation, where will you be living?
4948 Lawndale.
And who lives there?
My mother.
Who else?
There's two other couples. There's Lindsay's daughter, my niece, and her boyfriend, and another couple.
Okay, where does Lindsay live?
Lindsay lives at the lake, Toledo Bend.
So you understand that you're not going to be able to have contact with Lindsay.
Yes, ma'am.
So if there's some family get together at the house where you're living, you're going to have to leave if she comes over.
Judge, I do have that address as her address in my file. I'm not saying she doesn't live at the lake or whatever.
Okay.
And I'll let the court know she called yesterday, spoke with my investigator, wanted to drop charges. But because of the evidence in this case, I think I could prove it regardless. That's why we reached an agreement this morning.
Okay, so what I'm going to do, Mr. Broussard, based on the nature of your plea agreement, is reduce your bond pending sentencing to $1,000. If you make that bond, there's some very important conditions. First, the very first thing you do when you're released is go to the probation department so they can get that pre-sentence report done. If you don't do that, you run the risk of me not accepting the plea agreement. The second thing is that you're to have no contact or communication with Lindsay Gaspard. So if she is living there, you're going to have to find another place to live. You're going to have to figure that out, okay? If I find out that you're having any contact or communication, or she contacts the DA's office and lets them know that, then you run the risk of me not accepting the plea agreement. All right? Okay, you can go back with the bailiff.
Thank you, Your Honor.
Thank you. Jacoby Frazier.
Was it competency?
Let me just go through, y'all don't have an agreement, just, yeah, y'all just need some time?
Yeah.
Okay, I'll make that finding and then reset it.
He's competent, so Fraser. Fraser.
Hey, Judge Wicks.
Good morning, you're Jacoby Frazier?
Yes, ma'am.
And Mr. Frazier, it was evaluated for competency to stand trial by Dr. Pond in cause number 25 DCCR 0732. I've received that report and will take judicial notice of the court's file. Excuse me. That report is dated November 3rd of 2025. The finding is that Mr. Frazier is competent to stand trial.
Yes, ma'am.
And is there any other evidence with regard to competency?
No, Your Honor.
Not for the state judge.
All right, then at this time, I will make the finding that Mr. Frazier is competent to stand trial. And then Ms. Holmes, do you need some time to get out and visit with him with that? And
I do know that last time we did have a plea agreement. I believe we had done the paperwork, but then there were some issues where he was needing to be examined.
okay, if y'all wanted to, if y'all want to attempt that, I can hold it. If you want to try to go through it today, then we can take all that into consideration and see if we can get there.
Yes, ma'am.
Okay.
Yeah, I'll try to do that.
Okay, I'll hold it to see if we can get it taken care of. And if you need more time, just let me know.
You're gonna talk to me today?
You still have the paperwork? Hold on, hold on. Do you want to talk to him for a minute first? And then,
Yeah, let me.
okay, go ahead and send it, but y'all visit and I'll hold it for a second.
Okay.
Mr. Lewis, you got Kadesha Eli? That's a sentencing? Bless you. Sneezing, coughing. Happy holidays. All right, you are Kadesha Eli. And Ms. Eli was previously in court, entered pleas of true to a motion to revoke probation on probation for injury to a child, elderly, or disabled individual. Entered pleas of true to counts 1 through 8. I've received an updated report. Has everyone had an opportunity to review that report?
Yeah.
Are there any additions or corrections?
Nothing to finish.
Come from the state, Your Honor, unless Ms. Lopez has anything additional to her updated PSI.
All right, thank you, Ms. Lopez. Mr., and there was not an agreement, correct?
Correct.
Mr. Lewis, you may proceed.
Well, Judge, Ms. Eli, like I said, was previously placed on probation out of this court. Early on during her probationary period, it seems she had been doing really well, doing well, of course, being able to comply with the terms of probation. During that time, of course, she started having personal setbacks as far as her living situation, as far as where she would live and things of that nature. I believe at some point she did talk with probation about that, as far as trying to get some help with that. And it seemed to be working out well, even gotten to, I think she was living with your grandmother. And seemed to try to get back on track, but at some point that situation didn't work out for her either. And that's when things started to really go downhill fast as far as the not reporting and things of that nature. And it kept snowballed on her. Since she's been in custody, she has been able to secure a more stable living situation, of course, with a brother that will be available to her if the court decides to reinstate her. Also, employment. She has some employment options that's available to her as well. That I think that was her main problem or issue was stability. And I think since during this time, while she was already searching for these options, Judge, but they, unfortunately, by the time they became available to her, she was in custody. Now, when I talk about the situation with her brother, for the living situation, that's also one of the job situations as well. Her brother works with Zumo Sausages, the Zumo company, and she actually worked there for a temporary period of time a while back, early on, and that job fell apart, but looks like it'll be open again for her to go back. So that's essentially what it comes down to. Just she's asking now that she's stable to try to see if she can have the opportunity to get out there and complete the probation like she initially tried to and wanted to.
What's the status of the theft in Orange, the new offense?
For as we know, the situation in Orange, there hasn't been a court date or anything up there. So it's still in limbo, at this point, Judge.
Okay. Ms. Malfino?
Judge, I think it's fortunate that we're not here on a violation that involves a child based on the underlying nature of this probation. But I also think it's unfortunate that she doesn't have any felony offenses, was given this many opportunities, and as this court is well aware, a very good officer to work with in Ms. Lopez, and she has not done what she has been required by this court to do. So I would stand with Ms. Lopez's recommendation and defer to any other comments she might have.
So, Ms. Eli, the problem that I have is that when you first got on your probation, we sent you to the cognitive track of ISF so that you could get tools to be able to be successful and do better and make it through probation. And when you got out of ISF, you were put on the high medium caseload so that you would have help with all of these issues that Mr. Lewis is talking about, help with places to live and with jobs. And you were given all of that. And so for me to say, okay, you've already been given all that and you didn't take advantage of it to give you some other opportunity and just let you out when I've already given you these sanctions. And the underlying case is just very, very serious. And the fact that you got a probation was was a big chance. And if you hadn't already been to ISF, then maybe I'd be thinking about, okay, let's do ISF or let's do something to give you some tools to do better. But we did that and you didn't take advantage of it. So at this time, I'm going to find that you entered your pleas of true to counts 1 through 8 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of the offense of injury to a child. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. This is not a plea agreement, and so you do have some rights to appeal. You can talk to Mr. Lewis about that. I'm handing you the trial court certification. It shows you do have that right to appeal. I need your signature on that, and I'll get you a copy of it. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, you can sign that, and y'all can take the bottom 2 copies. Let's see, Leonard Guillory, Mr. Lewis,
Yes.
2 cases. Guillory, and so since it's a plea bargain rejection on the new case, I want to go ahead and get probably please on that motion
And I've already talked to him about that.
with the state.
We'd like to go forward on the MTRP.
The motion,
first.
I would, okay. Let me find that. Where is he?
There should be a second amended motion to revoke. You have a second amendment?
No, I'm on the first amendment.
Yeah, that second amendment, amended one was filed.
I could print out a copy.
Let's see. I have the date that it was filed.
Looks
There's
like
a
August
second.
27th. So it should be the one that you have, but let me print it just to, Good morning. Are you Leonard Guillory?
Yes, ma'am.
And so, Mr. Guillory, let's start with cause number 25. Is it printing? Hold on, I can't. Yeah, there it goes. All right, in cause number 25, DCCR 0902, you're charged with aggravated assault with a deadly weapon from June 19th of 2025. The indictment alleges that you were previously convicted of a felony offense, which means for punishment purposes, if you were found guilty, you would be considered a first degree enhanced, and the minimum punishment would be 15 years up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here on the tablet that you signed with Mr. Lewis that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year term in prison that would run at the same time as a 10-year term in that motion to revoke your probation case. You have every right to reject this offer and have this case set for trial. I do want to make sure you understand what the possible consequences are and what your options are. And do you want to reject that offer and have that case set for trial? So what we're going to do now, Mr. Guillory, is go through that motion. I'm going to get pleas of true or not true on that motion, and then we'll have a hearing on that motion first at a later date. I'll make a decision on that motion, and then we can go forward with your trial after that, okay? So will he waive the formal reading of the motion?
He does, Judge.
In cause number 22-40982, I have a second amended motion to revoke your unadjudicated probation. Shows that you were placed on probation June 26th of 2024 for unlawful possession of a firearm by a felon, a third-degree felony, and that was a 7-year deferred probation. Is that correct? Speak up, please.
Yes, ma'am.
Thank you. And it alleges that you violated your probation. Count 1 alleges that you committed the offense of burglary of a vehicle June 8th of 2025 in Hardin County, Texas. And is that true or not true? I'm sorry?
Not true.
Okay. Count 2 alleges that you failed to immediately report the arrest from June 8th, 2025 to your probation officer. Is that true or not true?
Not true.
Count 3 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
Not true.
Count 4 alleges that you failed to provide verification of participating in an education program for your GED. Is that true or not true? Count 5 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy, the MRT program.
Not true.
Count 6 alleges that you failed to pay your court-assessed fees as directed, and as of June 16th, 2025, you were $1,140 behind. Is that true or not true?
True.
And then it says second amended, but it never said first amended, so I think it's probably what we were all thinking it was. Anyway, count 7 alleges that you committed the offense of aggravated assault with a deadly weapon June 19th of 2025. And is that true or not true?
Not true.
Count 8 alleges that you committed the offense of evading arrest or detention with the use of a vehicle June 19th of 2025. Is that true or not true?
Not true.
Count 9 alleges that you possessed a firearm on June 19th of 2025 in violation of your deferred adjudication order. Is that true or not true? All right. So did you enter your plea of true to count 6 freely and voluntarily? All right, then I'm going to find that count true, find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that today. I'll reset it for a hearing and ask the probation department to do an updated report. Mr. Coleman, does the state anticipate witnesses with regard to those the offenses that are alleged?
Yes, or at least a couple of witnesses.
So we'll set it on a date when we're not in trial, not a docket date, so that we have time to have that hearing. All right, you can go back with the bailiff. Charles Monroe, Mr. Lewis. There's no paperwork on this one.
Judge, we anticipated doing a rejection on it, but there is some information that's still outstanding that I need to check into.
Okay.
Before we make that announcement.
Okay, do you want me to bring them out and do that, I guess?
I've talked to
You've already talked to them. If you'll just let them know, that's what I'm going to reset it for. We'll reset Charles. Will you let them know for real quick? We don't need Charles Monroe. Oh, what about Hakeem Thomas?
Hakeem Thomas, his parents actually showed up today and provided us with some more mitigating information on him.
Okay.
So I know we need some time. We got to talk to him.
Sure. All right, I'm going to reset Hakeem Thomas also.
He's the co-defendant, Judge, just so you know, to Hartley that Mr. Parker had, who rejected the 20 on the conviction.
Okay. Okay, perfect. Thank you. And then Deshaun Vital, or is it Vital or Vital? Good morning. Are you Deshaun? Is it Vital or Vital?
Vital.
Vital. And Mr. Lewis, will your client waive the formal reading of the indictment in each case?
He does, yeah.
Mr. Vital, in cause number 25 DCCR 1107, you're charged with a first-degree felony offense of aggravated robbery from July 10th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then in cause number 25 DCCR 1109, you're also charged with a first-degree felony offense of aggravated robbery from July 10th of 2025. And how do you plead in that charge?
Guilty.
And are you pleading guilty freely and voluntarily? And again, because you did what they charged you with. In both of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes,
Do you fully understand them?
yes.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a 10-year deferred probation that ISF would be ordered. So when is your 18th birthday?
April 8th.
Okay, so it'll be less than that at sentencing. So
Right.
we'll do upfront time until your birthday, and then you would go to ISF. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Vital is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. So are you at Minnie Rogers or at the jail?
Judge, can I address something?
Yeah.
Obviously, Mr. Vital has been in custody for several months. He's going to continue to be in custody for several more months. While he's in the Jefferson County Correctional, he's mentioned multiple times in reports, typically he's a victim of other people's behavior. There are a couple instances where he's doing things he
Yeah, I
shouldn't
don't
do, but
see
it's
many at
not,
all.
it's not the worst of the worst. It's not my concern. I just wanted to explain to him that it's important. And the last note I saw was that he'd been moved out of a dorm where he was being victimized
Yeah,
and bullied.
yeah.
I want him to be successful. I want him to
I
understand
do
that
too.
those reports can change. What gets reported between now and sentencing can change what happens in this case.
Sure. Thank you, Mr. Nichols. And I was going to address that. And you may have heard out there already that incident reports at the jail don't go over very well with me. I do understand there's been some things going on that weren't your doing. And so you just keep doing what you need to do to keep your head down to make it until we get to sentencing so that you can be successful. You're doing the right thing. If we end up with some reports and you change your behavior, which I don't see any reason to, you've been doing pretty well. And it sounds like the jail has taken notice of what's going on and where you need to be. But just continue doing what you're doing so that when we get back here in a few weeks for sentencing, I don't have any issues and Mr. Nichols doesn't have any issues to look at with regard to jail incident reports, okay? All right, you can go back with the bailiff. Thank you.
It's bad when I read the report and all the other names involved are.
The ones,
They're no.
yeah. And
they
they're
move
bullies and
they move
mean.
out that
Good,
door.
yeah. See, is that all you had, Mr. Lewis?
I think so.
Okay. Mr. Rojas on Robert Joseph Jr. Would y'all, I'm gonna print one, if you print the other, please. It's in TRPs. Robert Joseph, if you'll print the somebody print the second one, please. Give me just a second. Get these printed out. Look, I can probably get it before you with your computer. You got it? Yes, ma'am. Okay. All right, well, you're Robert Felix Jr., Joseph Jr., and will your client waive the formal reading of the motion in each case?
He will, Your Honor.
In cause number 21-38610, I have a motion to revoke your community supervision. Shows that you were placed on probation May 8th of 2023 for the first-degree felony offense of manufacturing or delivering a controlled substance. And that was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes.
And cause number 21-38611, I also have a motion to revoke your community supervision. Shows that you were placed on probation May 8th of 2023 for the third-degree felony offense of unlawful possession of a firearm by a felon. And that was also a 10-year sentence that was probated for 10 years. Is that correct? Each of these cases allege that you violated your probation. Count 1 in each case alleges that you committed the offense of public intoxication October 3rd of 2025. And is that true or not true?
True.
Count 2 in each case alleges that you failed to maintain your financial obligation to the GPS device company, failed to charge that as well. And is that true or not true?
True.
And then count 3 in each case alleges that you're behind in your court assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 in each case freely and voluntarily?
Yes,
And did you plead true to those counts because they're all actually true? In both of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand if I go along with this agreement today that you'll be waiving or giving up any right to appeal? Do you also understand if I go along with this agreement that this is a huge opportunity based on your history and what you're in here for?
Judge, if may I provide the
Sure.
explanation
Yes, ma'am.
to the court? I certainly agree with what the court just said. I know this defendant from his being here before. He's not somebody that needs to be in this courtroom. He's 18 hours shy of college degree. He was a college football player. He got totally off track.
Yeah.
And has just, I've spoken with him in the back. I've spoken with his probation officer. She asked that the court consider this sanction and allow him to be released for the holidays with the understanding that the pretty low offer that Mr. Rojas and I had discussed previously is now off the table, that he will be on zero tolerance if the court would allow, that he will have to continue to have that GPS on and show you that he can do what he's supposed to do with it. He was hemming and hawing back there about how much he spent on it. And I told him, in my opinion, he's gonna have to prove to you that he can stay on that GPS and do what he's supposed to do and do what Ms. Bradley asked of him, what you asked of him. And if he does that, I'm willing to give him the opportunity, if you are, with the understanding that if he's back, I will ask for the full time.
So, and I recognize you as well, and I know you shouldn't be in here, and it looks like you were doing well for quite some time. And so I'm gonna do what everybody feels like you have the opportunity, your probation officer, the district attorney's office. Because of the nature of the offense and what was going on, at least for some amount of time, you're gonna have to wear the GPS monitoring device. And so I know it's not cheap. You're gonna have to get a job and figure it out. It's very important. It's charged at all times. It's paid for. I've got to know where you are and that you're doing the right things.
Yes.
If you do that for some amount of time correctly, it's always charged. It's paid for. You're up to date. Then you can ask your probation officer to ask me if I'll let that go. And I probably will.
Sorry to answer the extra, Ricky.
They send me, so I have a box in my office that I get a pile of stuff from probation every single day. Early terminations, requests for monitoring device to be, all of those things. but they're not going to send it over and ask me on your behalf if you have not done everything you're supposed to.
You told me I had to hire another lawyer.
Well, they can send it over. Now, if you want to, a lawyer could file a motion, they can send the request over for you. But, and I'll take a look at it and see what all's been going on and talk with your probation officer again about how long you've been on it and what's been going on. If there's any change, I'll let her know. But for now, based on the new allegation, you need to get it, keep it, and then I'll reevaluate that. Okay?
Yes.
So this was a plea agreement, obviously, that I followed, and so you've waived any right to appeal. I handed you the trial court certification that shows that. All right. Good luck to you, sir. You can go back with the bailiff. Oh, and so, sorry, I feel like I skipped everything, actually. So the agreement was also for 60-day jail sanction, and that's with credit for time he's been sitting. And he has you've been in there.
Day 64.
Okay, so state tenders number 1.
Objection.
It's admitted. Any evidence that Mr. Joseph is not competent.
Okay.
All right, then I am going to, again, follow the agreement and continue you on probation, order that 60 days up front as a, but with credit for it as a sanction in both of your cases. And so you should be released today, it sounds like. Go straight to probation, get everything back in order, and then you'll be fine. Okay? All right, good luck to you, sir. And Mr. Rojas, that's all for you, right?
Yes,
Okay, so Ms. Holmes. Do you want me to go forward with Jacoby Frazier? All right, let's get Jacoby Frazier. Okay. And did I just held the sentencing for the evaluation, so we don't even have to go through. I can just sentence him, right?
Yes, ma'am. And I don't know if it's on there, but he definitely needs to be on the mental health case.
Yeah, I put that on here before, and so obviously we know that as well now. Okay. All right, again, you're Jacoby Frazier?
Yes, ma'am.
So Ms. Frazier, Mr. Frazier, I gave you an opportunity to visit with Ms. Holmes about your case. You had already entered a plea of guilty before, and we had come back for sentencing, and then I wanted you to visit with that doctor to make sure that you understood everything.
No, I understand.
And so do you want me to go forward with your sentencing today and give you that probation that y'all talked
Yes,
about? Any issues, Mr. Coleman?
No, Judge.
So, Mr. Frazier, I'm going to follow the agreement that you made previously with the district attorney. Find that you entered your plea freely and voluntarily. Again, find that you are mentally competent. Sentence you in accordance with that agreement. I'm going to defer all proceedings for a period of 4 years. You will be ordered to pay a $500 fine, and you're going to be ordered to follow all of the rules and conditions of probation. Part of those conditions are that you follow through with any treatment for mental health care through Spindletop. So if there's classes or counseling or medication, whatever it is, that's now not just part of what you probably need to do, but it's part of your probation. You understand?
Yes, ma'am.
So if you don't go to your appointments at Spindletop and you don't take your medicine like you're supposed to, then it could end up with your probation getting revoked, and you could go to prison for up to 10 years. Do you understand?
Yes, ma'am.
So it's very important that you do everything your probation officer tells you. Okay? So I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Obviously, you need to be on the mental health caseload as well. Yeah, it was already done. And so you'll be released from jail today. It's very important that the first thing you do is go to the probation department. The probation officer is going to talk to you today here in court. She's going to tell you where you need to go, and you need to make sure you try to get there today, okay?
I will.
Okay, good luck. You can go back with the bailiff.
And I have the paperwork where the probation.
She's going to give it all to you. She's going to give it to you. You'll have everything in writing.
Thank you, Ms. Harmon. Thank you, Judge Wade.
Yes, sir. You're welcome. Happy holidays, Mary. God bless.
John Jerry, did you do this for you? Oh, yes, okay.
Daniel Pierce, Ms. Holmes. There's no, we don't need him.
No, I'm gonna need some time.
Okay.
His parole officer may have some additional information.
Okay, so does he have a parole hold also?
I think so,
He's on
yeah.
parole through next year.
Okay, all right, we're gonna reset Daniel Pierce. What about
As well
Kevon
as
Saunier?
The same,
We're gonna
I
reset
need to reset him.
Mr. Saunier
Yes.
and then Latrick Williams.
I didn't have him on my docket.
It was set for a review. Let me look at it.
I don't know what we were doing on him.
What does OCA in parentheses mean? Anything that, huh? Oh, it's not anything. Who's got? I say oh, wait.
We brought him back because he wasn't sentenced right.
Yeah.
Oh.
I knew it was familiar, but it wasn't clicking in my head.
Yeah. So the sentencing, the
So-
offense information, okay.
All right, so this is Mr. Smith on Latrick Williams. Apparently, the MTRP alleged a third.
And it was a state judge.
And so I sentenced him on a third. So I think we can probably orally, I don't know, it's past 30 days. Yeah, I mean, I think we just need to.
We're just doing nothing for time? We have to reset.
No, because I have to resentence them and say all the right words. Yeah, I mean, I sentenced them to TDC, so, I mean, that was that, it was an agreed punishment. And so obviously the punishment is gonna be different in everything. Honestly, what I think y'all need to do is, we'll put it on the record that with everyone's permission, even though the time has passed, I would grant an out-of-time motion for new trial and reopen the case today. Y'all can do the correct paperwork with an agreement on state jail felony. You can do an oral motion to amend the motion to adjudicate so that it reads correctly, state jail felony. I can do the sentencing and everything today. I don't know, I mean, even that, I think I can grant that out of time motion, as long as there's no objection to it. So why don't y'all get the paperwork done? When you come back with him, we'll do all of those things formally with. He's here?
Oh.
Yeah. So get the new paperwork done, and then, well, how does that work? Because the old paperwork is already. What does that do, the old paperwork? If I do just a new trial, it gets rid of it, right? Yeah.
Well, I
Okay.
mean, it'll still be in the case, but we'll.
It'll show that there was a new trial
trial.
granted.
Yes, ma'am.
And we'll just do a memo that says I orally granted that. Make sure there's a memo that's in the file that says that, and I can sign it or something.
Yes.
Okay, so get the paperwork done on the new punishment that you guys agree on.
Okay.
Okay? And then I'll take care of him. Who is Isaiah Brown? Who is Isaiah
We've
Brown?
already done that.
Oh, that's the one that didn't send to you for some reason. It's still sitting here. That's the one that gave me all kinds of trouble. Let me see if I can sign it now. And then, and I don't know what, what did I do with him? Did I not go through with the plea and sign
You
everything?
finished it all. It just, the tablet wouldn't let you send it to me.
It just showed it's all blank, so I just signed it all again. And now I'm sending it to you. I don't know what happened.
You did it.
Okay.
Because you were trying to send it to me.
I know, yeah. Okay, it's done twice. What about John Dre Willis? Did I already do that? Whose is
You just
that?
have to- You know, I have it.
I have it. Whose is it? I've been,
Yeah, it's was ready. We just hadn't got to it yet.
I got yours, Ms. Holmes, as well. Let's do that real quick, and then while you're doing that paperwork, I can get started on Mr. Kimmler's hearing. All right, John Dre Willis. What, I folded my pages over before I got done with stuff. You need one too?
Sorry, excuse me.
Good morning. Are you John Dre Willis? And will your client waive the formal reading of the indictment? Mr. Willis, in cause number 25, DCCR 1048, you're charged with the second-degree felony offense of burglary of a habitation, and that's from June 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Answer out loud, please. And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $300 fine. There would be a dismissal in misdemeanor cause number 25 CCCR 1654, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Speak up.
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Willis is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. Ms. Malfino, what is the state's position with regard to bond?
I have no objection to PSI bond in this case. The court will recall that on October 21st of this year, this defendant was before you with respect to a bond. The complainant was also here. Just to be candid with the court, she has been very back and forth, so to speak, about her desire to prosecute or not a misdemeanor versus a felony. I spoke with her again a few times yesterday. This is what she asked me to do, is put him on the felony probation with the court to supervise him. I would ask that in the interim period that we go back to those bond conditions, or PSI bond conditions, whatever we need to call it, that were a no contact with the complainant, a GPS monitor, and the fact that you ordered him to reside with his mom in Iberia Parish at 726 Mergery Street. He's just been unable to post that $7,500 bond that you gave him that day, so he's been in custody this entire time.
Okay, do you understand all of that? And you understand if I reduce your bond today, that those are all going to be conditions of your bond? I understand that Ms. Richards has gone back and forth and you guys are going back and forth, but until sentencing and possibly beyond that, you're not to have any contact or communication with her. She can't give you permission. I think I went over all this probably at that hearing. She can't give you permission to violate my order, okay? She can't. So, and you're still planning on going and living with your mom in Iberia Parish, correct? So what I'm going to do, Mr. Willis, is reduce your bond at this time to $1,000. I am going to order pending sentencing if you make that bond. And do you think you'll be able to make the $1,000 bond? Okay. So you're going to be ordered to get a GPS monitoring device. And so the bond is lower. You're not going to have to pay a lot to get out of jail, but you are going to have to pay for and keep a GPS monitoring device on until, at least until sentencing, just so I know you're doing the right thing between now and then. Okay. We'll discuss it again at sentencing. And you're ordered to live in Iberia Parish with your mom and remain in Iberia Parish, except coming back to Jefferson County for court, okay?
Can I ask you something?
Uh-huh.
I have a son in Lake Charles. Would I be able to visit?
Yes, you can go to Lake Charles if to visit your son. So whatever, do you have court orders or do y'all just go visit? Okay. So the main thing is that you're not back here and you're not having contact or communication with Colette Richards, okay? All right, we'll see you back at sentencing. You can go back with the bailiff. And all of those bond conditions should be on something I already did with the address. I remember writing all that down. So then Ms. Holmes is working on that. Mr. Kimler and Mr. Smith on Victavia Sanders. We can at least get started. I might take a break depending on, it's not gonna take very long. Yeah, all right, Victavia Sanders. And today we're really just set for the sentencing on that MTRP, correct? Is there a? Probably easier to see because I can also watch it from there here.
You want us to sit at the table or?
And y'all can just stay here since we don't have a witness. We'll just we'll do it this way. All right, ma'am, you're Victavia Sanders. And Ms. Sanders was previously here in cause number 22-39884. Entered pleas are true to counts 2 and 3 and a motion to revoke community supervision. I received an updated pre-sentence report. We're here for a sentencing hearing. Has everyone had an opportunity to review that report?
Yes, Judge.
Are there any additions or corrections to the report?
Your Honor, my concern, I guess I can address this after Mr. Smith had the opportunity to present evidence on the new offense, was that the recommendation appeared to be predicated on an assumption that the new offense had been proved up. And that was going to be my issue with the pre-sentence report. Of course, if Mr. Smith is prepared to prove that.
Okay, let's go through that.
The necessity for me to run that.
All right, we'll go through that first. And it's my understanding, and we spoke earlier, kind of off the record, that the officer involved is unavailable, but that Mr. Smith has his body cam video footage from that date, and there's no objection to him putting that on as evidence in this hearing. Is that correct, Mr. Kimler?
Yes, Your Honor, that's correct. My understanding is due to the exigencies of the officer being involved in the shooting, he's on administrative leave and is unavailable to testify. I therefore don't have any objection to the body cam being played in his absence.
Thank you, Mr. Kimler. And just let me know when you're ready, Mr. Smith. And Ms. Lopez is here. Thank you, Ms. Lopez. And at the appropriate time, if you have anything to add as well, I'll give you an opportunity to do that. And so the allegation in count 1 that was not pled true to or not is the allegation of a new theft of property from July 31st of 2025 here in Jefferson County.
He's got to play the video.
Sure.